Good morning. This is the New York City Board of Standards and Appeals for June 20th, 2017. This is special order calendar. Item number 1, continued hearing, 20262 BZ, 950 Allerton Avenue, the Bronx.
Okay, I just wanted to make sure, I'm not sure because there's not a lot of people here yet, that if anyone's here for the IFC movie theater, is anyone? If I could see a show of hands. No.
IFC
Okay.
movie theater?
Nobody's here for IFC. Okay.
Let's see.
She just pushed the button and it did that.
Right.
Okay, 1 second, sorry.
Oh, you got it? Maybe switch the mic.
Yeah, okay.
Okay.
That was the room.
Sorry.
That's what happened yesterday, yeah.
You can proceed if you want.
Good morning, Chair Perlmutter and Commissioners of the Board. Jacqueline Calcagno of Ackerman for the applicant. I'd like to respond to the question raised yesterday about the concrete slab. That area was where the shed was located, so when it was removed, the concrete slab was not removed, and the owner would like to keep it for employees to have their lunch outside, if that's not possible.
So is that, in other words, you're going to put like a picnic table on it?
And he didn't say they were going to put, I think they would just go out and sit over there.
Yeah, just to be clear, it's not to put the shed back onto.
No, no.
Right, okay.
Yeah, no.
Okay. Do we have any other comments? Are there any speakers on this one? So I think, as we said, we can close this, okay? So I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. And I'd like to make a motion to grant on condition. The first condition being that there's no storage shed to be installed on that pad or elsewhere. The site is to be maintained at all times, clear of debris. Building walls and fencing shall be painted and repaired as needed. Landscaping shall be maintained and replaced as needed to ensure continuous dense 8-foot high buffer between the site and the adjacent properties. Driving surfaces shall be maintained and repaired as needed. No temporary storage sheds are permitted. No signage permitted in excess of what is shown on the approved plans. No open storage of any kind, and the site is to be maintained clean and free of debris and graffiti. So, any other additions to that? Okay, so on those conditions, a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Thank you.
Thank you.
Item number 2, 3695 BC, 6575 Woodhaven Boulevard, Queens.
Good morning, Todd Dale for the applicant. From review session, I know there were a few questions that were raised. First, regarding those signs directed to patrons, I suggested to them, and they're going to try and make bigger font signs. They're the signs that have been there, but to the bigger point, they've noticed no issues with patrons of the site parking on the side street. So whether we do it, it's all owed to those signs or not, they will look at those signs. There was a question regarding the elevator contracts that were submitted. Just to clarify, the one was an electronic signature. That's why there's no actual signature on it. It was submitted to the company. There's 2 companies. One does the monthly maintenance, cleaning up the elevator, making sure that it's up to snuff and operating. The second is the one that's going to go back and correct those violations, those open violations that have been open for a few years, and schedule the required inspections. They have scheduled an inspection. The soonest they could get was October. So it's taking, maybe not all parts of the Department of Buildings operate as quickly as we want them to. So October is when they're having an inspection, and they're expecting it to pass, and we'll do whatever is necessary to get those inspections done.
Okay.
There was a question, I think, also to clarify with the plans that were submitted and the fire safety measures that were installed. The notes that were on the interim set of plans were the standard PC notes. The original approval was a variance, and there were no requirements set forth by the board regarding installation of sprinklers or fire alarms or any fire safety measures. The initial plans that were submitted reflected that. When the architect changed recently, had an assistant who went to the BSA website diligently and saw the PC notes, threw them on the plans, and then these recent plans have removed those notes. To clarify, there is a sprinkler system that's installed. I have one set of color photos to show the board, and I I can pass those up if you want to see it. There is a sprinkler system installed, and there are Department of Buildings jobs that were signed off for the sprinkler installation. There is no fire alarm installed. There was no requirement from the original grant. Regarding the place of assembly permit, just to note, they have it in place to move forward with the PA permit. They're working with the architect. There was plans that were filed. I believe Mr. Scudo can speak to that, but they have an account number. They're ready to move forward. They can't get the PA permit until they get the certificate of occupancy updated, and they can't get the CO updated until this grant. There was a lapse. It should have been done. There's no doubt they should have had a PA permit, but as evidenced, I think, by this application and then trying to move forward, there were some life circumstances associated with the particular operator. We're past that now, and he's really trying to get this back in order, both through the BSA and with the fire department.
But it's not the same operator, Roll Jim?
It is the same operator. There was a couple of, I think there were co-operators. Now he's the sole operator who was there. Still World Gym, and the principal is the same.
So it's been operating as a public assembly since 1997 without a PA permit.
It has, and we're trying to rectify that. But to note, with the conditions that were set forth with the previous grant, they did get the certificate of occupancy. The CO was issued by the Department of Buildings, and all the conditions of the previous grant were met with. There's no excuse. The PA permit was not done, but they are really trying to move forward, and I think evidenced by the fact that they've engaged the elevator company, they're working with our office, they're working with the architect, and they're really trying to get it back to where it should be. And with the PA permit, the expectation is upon this grant and getting the CO, that they should be able to get the PA permit within 6 months of getting the CO, but we'd agree to a condition, if the board would like to put a condition that a PA permit must be obtained within 12 months, maybe provide a little buffer, whatever the board thinks is appropriate. We're definitely going to move forward with the PA permits, whatever condition might be appropriate.
Yeah, but what's the... They had that condition before.
Well, there wasn't a specific PA permit condition in the resolution, but I know what you're saying as far as enforcing it.
Yeah.
For this proceeding, putting it in the resolution, we'll agree to. I don't know what other.
Because there's no
I mean,
way
the question too, also with this application, is that there was. I don't know what should this be granted. I don't know what the appropriate term would be for this, because there was a lapse. But they're trying to move forward. Maybe if the board issued a shorter term in order to check on that condition. I mean, we obviously would like a term of sufficient time for the effort being put forth, but anything that the board thinks as far as checking on that.
Because it would have, the grant expired, I think it was 2002.
Two.
Right. Yeah, so if we granted you 10 years, you'd have to come back right away.
Exactly.
Like right now.
So as we understand, we understand the concerns. We're trying to move forward in whatever the board thinks is appropriate. As far as that, perhaps if this term were shorter, but then if everything was satisfactory, the next term could be longer. Something along those lines, possibly.
I'd like to hear from the fire
Sure.
department, so let's hear how they...
Good morning, Madam Chair, Commissioners Anthony Scaduto for the Fire Department. Okay, so just to clarify, yes, we do recommend that the board requires the interior fire alarm. There's no design there. The PA permit's very interesting on this particular case. There's existing drawings. There was an application. There's a number in biz. The drawings were produced. They were professionally certified, which with PA permits, I've never seen that before. But in any case, we've been inspecting, we have a PA account, we inspect them annually. We have been working from those drawings, but there are outstanding fire department violations for no PA issued, so it all makes sense. Now, the C of O has been revised, so it shows that it's a PCE. That would be beneficial in terms of installing the fire alarm system, because now we won't have an issue of the system not reflecting actual use. So basically then, just to sum it up, we would recommend that the fire alarm system be installed both in the first floor and cellar, and of course the PA permit be finalized as soon as possible. We have no objections to the layout. Existing conditions are fine. There are no fire department violations for operational problems.
Okay, okay.
Thank you.
Great, thank you. So since the C of O, as Mr. Scaduta said, since the C of O actually shows a PCE, right? You could apply now for the fire alarm installation. So, right?
We understand the fire department's recommendation. However, in this case, we have provided a sprinkler system. There was no condition of the original grant for a
Right.
fire alarm system.
That was-
And in this instance, this is a small, independent operator, and, we're not even sure, speaking to the building owner as far as a fire alarm. In this instance, because it wasn't part of the original grant, we don't think it would be appropriate to require this condition at this time. The board does have a precedent, Equinox Church Street, which is 2 blocks away. When it came back for renewal, it did not have a fire alarm system. It was not required upon renewal to install a fire alarm system as a new condition. So,
But,
we understand.
because we're not firefighters here, we rely very much on the fire department.
Sure.
Recommendation. It's just, a lot's happened since 1997, right? And we learn a lot about fires and how to prevent people from being injured in fires. And it seems foolhardy that there wouldn't be something that warns everyone to get out of the building. I'm not sure why there would be so much objection to putting in a fire alarm. It's not like you have to wire the whole building, it's just to the
It's-
floor.
Because of the size of this operator, and independent businesses is the only business they have, it's a significant expense to undergo this. It's also a new condition. All the conditions of the previous grant were met. There is a sprinkler system
Well,
installed. The
not
sprinkler system
really,
does have.
not really, it's been expired since 2002.
But the condition was to obtain a certificate of occupancy. The specific condition of the resolution,
And
specific
to
conditions were
obtain a
met.
PA permit and to renew after
The PA permit wasn't part of
expiration.
the original grant.
It was required on the C of O.
But as I said, as far as being.
No, but it's not as if that the owner has been, or, the operator has been in compliance. It's been an expired permit for 15 years. So how is that showing that everything
No,
was
understood,
been
and that's
on
why
the
they're
up and
here
up?
trying to move forward. But as I say, there's also precedent with the board, that's just one. There's other sites that we've had that are PCEs, whether special permits or variances, haven't had fire alarms, and they haven't been required to install fire alarms on
I don't
subsequent
know what the
grants.
specific situation was in those cases. Yeah.
Anthony Scaduto, Fire Department. Just to reinforce the fire department's position, if there was an oversight in the previous SOC case where originally granted without a fire alarm, we were remiss in not reminding the fire department, the board, that we now require fire alarms. That doesn't change the conditions here. Yes, we understand it's an individual operator, it's not a large corporation, but the premise itself requires a PA permit. The occupancy is well over 100. So when we use the term small operator, yes, we understand he's a small businessman in terms he only owns one location, but this particular location serves in excess of possibility of serving in excess of 100 people. In addition, Besides the first floor, there's a cellar occupancy here. And, our position is that notification in an emergency situation is very, very important. You have a cellar occupancy, which is totally removed from the surrounding areas in terms of being able to observe general conditions. In any case, using another location where fire alarm wasn't required really is not, from our standpoint, an adequate reason not to require one here.
Right.
Yes?
I have a question. So, is going forward, we should be
You are
should we be requiring this for renewals?
You are
when-
requiring them. You have been.
In some cases, I know we omitted, so
Well,
that's
no,
why.
but sometimes they're tiny places. They
Well-
really are like a spin studio where there's
Right.
one studio and that's it. and
Well,
they're upgraded.
there's been some ongoing discussion in terms of, alarm systems in general.
Right.
But the larger locations, historically, it wasn't a specific requirement by the board, and certainly it was added later on. The renewals on those places that pose a significant danger, let's say, in terms of the amount, the locations in the building, the population in terms of possible occupancy, those are the ones that we feel.
So those are the criteria you're
Yeah, and
using.
we feel
So
that
that's
that
why
it's
we-
fair
In some
to-
cases, we are more emphatic in other.
If I have a, let's say, a yoga studio where the occupancy is 20 max, and they've operated without a fire alarm system, even on those cases, what the board has agreed to is a local hardwire smoke detector as opposed to a full fire alarm system. So we are upgrading the notification aspect of these locations. On some of them, we're going for a very minor installation, but we believe now that this should have been something that was required from day one when PCEs were first established. So we stand firm on recommending.
I mean, thanks for the clarification. I just, now I understand.
Thank you so much. Thank you.
Thank you. Okay, so you've heard the fire department, and I don't see how we can ignore those kinds of safety concerns. I mean, I think that what you could do is you and your client and client's architect could work with the fire department, figure out what kind of system it would be an acceptable system, so we're not going to specify it here, right? But given that it took 12 years to get here, I think that work needs to be done now, and getting the PA permit into the stage where all it needs is, I mean, I'm not really sure what holds it up from being granted, but all it needs, say, is a grant from the board, and kind of the next day it's granted, so that's the open objection. Essentially, it's filed, and there's just an objection that says you need the CFO updated. Seems to me if you got to all of those stages, then we'd be in a position to perhaps grant a longer term, because all the conditions are being satisfied up front. 'Cause, I mean, you've been this long without, right?
Understood, and, we understand the fire department's position. If we were to work with them to get the entire for condition to install an interior fire alarm system, fine, we understand it. Our primary goal here, though, is we want to be able to get this PA permit as quickly as possible. And it's our understanding that because that CO has the term on it, that we cannot get the PA permit. I know what Mr. Scuduto said, but that we really need to get the CO without an expiration on it in order to get the PA permit. And our hope is to accelerate that process, because that's very important. So installing the fire alarm, if we were agreeable to that condition, we're hopeful that it could be a condition of the resolution and not stop the resolution until it's installed. Because we don't want to slow one down in order to get the other.
But I don't actually get why you need why do you need the PA permit? The whole idea of a PA permit is to make sure that you've got a safely occupied space.
Sure.
That the fire department is ensured that there is not an occupancy greater than what can be handled, that you've got adequate egress, sprinklers where required, fire alarm. So this is all going towards making the space safe.
Right.
So the actual piece of paper of PA permit, when you don't even have a C of O and haven't done so in 12 years, or a PA permit, I'm not understanding what's the need for this
The
piece
issue
of
would be
paper?
is that the fire department, they come with inspectors, and we don't have a PA permit, will issue violations for significant penalties.
You're working with the fire department.
Different departments, though. If Mr. Scuduto could guarantee we weren't going to get violations during the interim period, great.
Well, it
But
doesn't-
there's,
Right, but at the same time, you've been in violation of your C of O, the requirements of the C of O, which was a PA permit, for 12 years. Here you are in a place where you can now quickly get a fire alarm system, bid on and install. We've seen it done in very short order. And then we could give you a long-term on this PCE. So, because otherwise, I don't see how we're going to see the work done. The site doesn't have a history of complying with conditions, basically, right?
if this, perhaps this be the situation, if we adjourn this hearing and we work to get a interior fire alarm system that's acceptable to fire department installed expeditiously as possible.
Yes.
However, if during that time, if we apply to get the new PA permit, and we're told by that department that we can't do it till we get the CO updated and we come back, would the board then be agreeable to some sort of condition where this, because we can't get the CO updated until the board grants a resolution. So,
Understood.
we understood.
Right.
So we can adjourn with the understanding that we're going to work expeditiously to get the fire alarm installed. But I just want to note on the record that if for some reason, while we're doing the fire alarm, but we're also working towards a PA permit, if we're told that the only thing holding up the PA permit is amending the certificate of occupancy, which we can't do without the board, would the board then be agreeable to issuing a resolution with conditions so we could get the PA permit? I don't know if I'm trying to make it clear.
Let's talk about that when
Okay.
we get to that bridge, because I'm not really sure what the thing is about the PA permit, and maybe the fire department can work with, maybe Mr. Scuduto can work with the other part of the department, so you don't continue to get violations, because you're working towards curing the public assembly issue, which is to make the space safe, right?
Right.
So
That's our
can't
primary
promise
concern.
anything,
Okay, that's fine.
but I think,
As long as the board's aware of that possibility,
Yeah.
then we would agree to an adjournment, and we will work towards installing a fire alarm, just with that understanding that perhaps the process has to change depending on what the PA permit inspection unit's estimates.
we'll talk about it at the
Noted.
next,
Okay.
yeah, please.
Anthony Scuduto, Fire Department, just to expedite. I'm going to request the standard system that we normally request. So that would be area smoke detection, pull stations at every means of egress, central station connection. There's no reason to vary or to make this a smaller system.
Okay.
So it's as per the standard notes. In terms of enforcement, they already have, the PA inspection unit already has outstanding violations. If they they're not scheduled to go out, but if they do go out, they'll just repeat the same violation. So there's not putting, it's not like double indemnity. They're not going to make anything worse. Like I said, we did confirm that the conditions on the site are acceptable, so the operator is doing a decent job maintaining it. So I don't foresee any, new list of violations being issued, other than the repeat violation for no PA permit.
So do repeat violations accrue additional fines?
What happens is there's the two forms. There's the NOV, the notice of violation, similar to DOB, which would then go to oath, and it culminates in a financial penalty. The other form that we have is a violation order. Repeat or non-correction of a VO could result in a criminal court summons for the owner or operator. This particular location, it seems that they've been out a couple of times. They haven't moved forward with any kind of a criminal court summons, and there's no indication that they intend to. I will reach out to the, just so Mr. Dale is aware, I'll reach out to the manager of that particular unit, that this particular location is currently at the board. They're intending to do X, Y, and Z, and, if they want to do a site location, but we will recommend, see, nothing is held in abeyance because they're at the board or they're at DOB. Yeah, obviously, life safety conditions are enforced as it's seen by the inspector. But there could be a recommendation that if they repeat violations, they do it at a level where they make notation of the violation, but they hold short of any criminal court activity. That I do have the ability to make a recommendation.
Okay.
So it would be a notation on the existing violations where it's in process, progress has been made, so they hold short of any further legal action. And that would be it.
That would be great, okay.
Okay, thank you. Thank you.
Todd Dale again. Based on that, that's great. We'll work with Mr. Scudo. That's the main concern, is that we wanted to avoid these repeat violations occurring while we were trying diligently to work for it. So
Okay.
we know what the standard requirements for the fire alarm. We'll reach out to the operator. We'll talk to the operator and the property owner about getting this done as quickly as possible. We'll work with the fire department violations and
Great, okay. And so, and while you're at it, you'll put a bigger sign.
Sure.
on Woodhaven Boulevard.
we'll go crazy. We'll go to 14-point font,
Okay.
20-point font, whatever it is.
Okay, so Ryan, you have scheduling?
Sure. How much time is this going to be?
This is going to need some serious time, like 3 months?
Sure, we can be flexible. I would say, I was thinking 2.5 months, so.
Two and
No, so whatever the board's calendar is, I'm not sure that,
okay.
sometime in
Hold on a
August or so,
second.
early September. Not the first week of September, but for
Yeah,
schedule,
yeah,
so
okay.
either late,
So what do you?
like the last week of August. I don't know if there's anything.
I don't know if we have anything left.
The August 12th or 22nd is probably fine for this.
Okay,
Yeah.
August 22nd?
Yeah.
So just as, I'm still trying to load the calendar.
That's August 2nd submission.
Submission, August 2nd, so that would be.
Oh. So,
I don't know, I mean.
Hold on one
if you
second.
feel like that's enough time.
yeah, right, so that's only,
Let's go to the,
July.
after Labor Day in September then,
Yeah.
perhaps provide a little bit more time.
The September 12th?
Sure, so September 12th would be the hearing and the submission would be,
it's public hearing, sorry. Download the public hearing, 2017. It needs to be bigger. It's not a big- Sorry, just 1 second, little technical glitch. Oh, thank you.
old fashioned.
Great. Okay, so what did we say? September 12th?
12th.
Yeah, so that's so August 23rd submission.
August 23rd submission.
Oh, but I
Okay.
didn't ask, are there any speakers on this? No, okay. August 23rd. Okay.
Thank you.
Thanks.
New case is item number 3, 55851BZ, 6822 Northern Boulevard, Queens.
Hello, Eric Palatnik. We attended your review session yesterday for one of the more finely maintained gas stations that I've had the pleasure to represent. There's not much to the station. We know you've been out there. It's got the pump islands and it has the kiosk. It doesn't have a convenience store. And we know you had some questions about the retaining wall in the rear with the dumpster. And whatever you would like to have done, our client is happy to do, but I'll tell you what is in place. We have for you to pass up to you a package, and I'll pass it up to Jess if you just pass this. Collated this time, we're getting better.
Start there. Start there.
You would hesitate.
Very specific passing out direction. I'll let everybody get that, so I'll see it then.
Thank you.
Oh. Sorry, are they all the same, or?
Each package has different, yeah, those are, just take one package and pass it on. Yeah, it's all the same.
More than we need, thanks.
So while they're making their way, I'll start with what's on the package. Right on the top of the package is a photo of the retaining wall, which is on the south property line, that has the fence on top of it. So that's what you were looking there, and you can see a better picture of it if you go to second page. You'll see also there. So that was your question yesterday. I don't think you were able to see it in the photos we gave you originally, because I think those were taken in the winter. And I think there might have been some garbage stacked up there. We can get you more closer pictures if you want. These were just things we
Sure.
grabbed off of Google last night in response to your request. The handicap parking space, we've spoken to British Petroleum, and they will be restriping the parking lot. We're hoping you could not condition the approval on, not require it to be done first and give us the approval first, but whatever satisfies the board, we'd be happy to do. And we went through the plan in the package also. We have the updated sign analysis form, which changed the proposed signage from 63 to 68, so that it's accurate and reflects
Does
what's
it have
actually
the
there.
sign that you have in the first photo?
Yes. Oh, no, that sign?
That should be removed.
No, I think that sign is probably an illegal sign. It looks like a promotional sign that British
right.
Petroleum puts up without any sign permits.
Right. Yes, so that should be removed.
Probably what I'm imagining that
I'm
is.
so glad you gave us that photo.
You know, that's always, whenever we ask for photos, we spend half our time telling the clients after we get the photos. You can't give a photo with garbage all over your property. You have to clean it up. So, this one we took off Google Earth though, so this is our own fault. So, we'll fix that. And what else was in the
Okay.
I made
package?
the comment
that's
about the
pretty
trash
much.
enclosure.
Yeah.
Oh.
In 1984, when you removed the building, when the building was removed, the resolution said a 10 by 10 trash enclosure will be installed. And I noticed that the dumpster's all by itself, and then you have these 3 55-gallon drums scattered around the property line.
Yeah.
Which I don't know what they're for.
I'll tell you. So the drums are, and I never noticed them before either, they're supposed to be on every automotive service, or a lot of automotive service stations. What they are is when there's any waste oil that's of car gassing up or something, British Petroleum has absorbent rags that they'll put down on the parking areas when you fill up. So if you overspill, you know, and you drip your gas, so they'll clean up.
So
And then
they
they go in
shut.
the drums to be disposed of.
So that should be in the trash enclosure area.
It should be in an enclosure area. We'll talk to British Petroleum and we'll see if they'd be willing to install an enclosure.
Well,
at
it
your
was in the
request.
prior
It should have been
resolution
there.
that since the building was taken down and there's nothing else there, that a trash
Shouldn't
enclosure...
be a problem. They're pretty accommodating with all your requests, so I just have to speak to them first. I can't make the promise on their behalf yet, but we should be able to do that for you.
Where's the notation on the plan for the guardrail? For the, that's up against the retaining wall? I see you put a note there for the retaining wall. I see
don't-
6-foot-high chain link fence, but I don't see the guardrail called out.
We could add that to it. It's easier to add it to the plans than it is to build it, so.
Oh, I see. Okay, no, maybe not, because there's a little notation that says existing steel guardrail that points at those little circles, and that says typical. So that goes all the way around. Okay, never mind, you don't have to do it.
Oh, I see, it up in the top, up on the left side along
Yeah,
the BQE expressway ramp.
Yeah.
Okay, yes, I see that.
So though, because the dumpster enclosure needs to be shown on the plan,
Yeah, we'll add it.
yeah.
We'll find it. I'll talk to the engineers. We'll find a spot.
Okay.
We'll talk to
But-
BP first, make sure they're okay with it, which I'm sure they will be. There's plenty of room.
Right.
You could just, I assume you'd be happy with it where the dumpster is located? That is suitable location?
Yeah, right? Well, it's near residential.
It's to the back.
It's allowed to be
It's-
that close to the front.
Right, it has to be 50
It has to be
feet from the
50
street
feet
line.
from that,
So-
yeah. So it probably needs to go,
We'll
yeah,
slide it
somewhere
back, almost by the air stations there.
Yeah,
Move it back off the line.
or to the, it actually has to move to like the middle of the property because you also have 69th Street on the other side.
The middle of the property that'll be hard, because you've got a lot going on in the middle.
No, what I mean is the middle along the
The
lot.
middle along the BQE side,
Along
The-
the lot line.
on which,
But that looks like, if
But
it's on the
that-
BQE side, it looks like it would possibly interfere with the car,
Yeah.
the vehicles.
Yeah, I think along the BQE,
Yes, potentially a car coming. I mean, we could put it up where it says existing air stations, the bottom air station, maybe you could fit over there. Why don't I let the engineers look at it and
Yeah.
see where they could find a suitable location? Because you do have the underground storage tanks in the middle, so be careful about a permanent enclosure around that.
All right, but it has to follow whatever the rule is.
Yeah, we'll
distance,
speak, and if we
yeah.
have run into a problem, we'll alert you to what our problem is.
So the
and
ideal, of
sure we'll come
course,
to a
so we
solution.
don't need to make it have conditions or have more than the usual conditions, is to get that work done now, so we know the site's in order, and then move forward.
But the dumpster would require a permit. Trash, combustion. The trash, the building enclosure would require a permit.
It does? Little fence enclosures.
Yeah. British, yes,
Check
yes.
on that, because I'm not sure. that-
They
They
wouldn't,
want a permit for you to
to put a fence in, you need a permit.
put a fence, yeah.
You can't just, yeah.
Okay.
British Petroleum, big national corporation, they won't just go and do.
Okay. All right, find out
So if
about
we
that.
can, I can get them to pave the, I mean, it's, they're pretty good at sticking to their word. I can get them to paint, they can certainly paint the parking lot right now, and we can change the plan. And if the board would like us to spend the time getting a permit to install the dumpster, we could do that. That just will take us probably 3 or 4 months, to get the permit and then to build it.
Okay. Can you verify that you really need a permit to do the enclosure? Because one of the reasons I'm asking is, we often
Yeah.
have this requirement, and we don't have, they just didn't, I mean, maybe they're doing it illegally, but we do see the trash enclosures.
I'll find out. I'd be
Take a
hard
picture.
pressed to find out that you can
Yeah.
build a permanent structure on a property without a permit from DOT.
Okay.
It's just because a fence needs one too, you can't just
Yeah.
go put up a fence, so.
Okay.
And I know what you're talking about, because other gas station people, the
just
gas
shows the
station business,
picture.
some people are a little more loosey-goosey when it comes to some.
Right, right.
You see them, they come to you, they're not always up to where they should be.
Right, yes. No, it's,
So-
okay.
But we will,
All right,
I'll
so
ask them,
find
and if
out.
we can, we can, if we can't, whatever, listen, the
Okay.
gas station's there, we're not asking to build anything new, nobody's in any rush, so whatever you decide you want to do it or how to treat it,
Okay, great.
we're along for the ride.
Okay, are there any speakers on this? Are there any other comments? All right, so how much time? You don't need a lot of time for this, right?
You don't need that much time. You can give us a hearing on August 8th. We can get back to you before.
Ryan?
August 8th.
Or August 15th.
The 15th would be better.
Okay.
Yeah, that would be good.
So then that's what, it's July 26th submission.
Yeah,
Oh,
that's great.
sorry.
That's okay.
You need another?
Yes.
No, I just, August 15th? Are we closing it or?
August 15th.
Yeah, August 15th, August 16th submission, no, August 15th hearing.
July
July
26th
26th
submission, you said.
so continued, right?
Yeah.
Item number
Thank-
4,
I'm sorry.
may we go on?
Yeah.
Item number 4, 82259 BZ, 1774 Victory Boulevard, Staten Island.
Hello, Eric Palatnik again for another gas station. This is a different situation than the last one,
Yes, sir.
as you know. The owner of the site is an operator that you've been very familiar with, and I think you've been pleased with their behavior in the past, which is Bola. Bola is the one that we've shown you. They have beautiful facades they put on their buildings, and they landscape them nicely. They have not had site control over this property. I have not been able to speak to them. Between your hearing yesterday and today, we weren't able to get in touch with them to find out when they will be able to get site control to address everything you're talking about in your comments. But you had raised a lot of issues about the current condition of the site, as well as to why things weren't done in the past. They just recently purchased the property. I don't know the exact time period that they did, but it wasn't at the time of the previous approvals, other than the extension. They came back to the original. In 2014, they came for the approval, but they have not been operating the site yet, is my point. There's another operator on the site. So they've been given the right. What they do, their business model, is that they secure their approvals. They enter into an agreement with the property owner, and while that property owner is still maintaining control over the property, they are given the right then to pursue approvals. And then they close on the property. During that, they set a date at which they'll take over the property. So I believe, and I haven't had the chance to speak to them, what you're raising of the issues has been through that business arrangement, where they haven't yet had control over the property, but they've been given the right, and through closing on the property and owning it, but then as a lease back probably to the owner, to the operator, to run the property while they're pursuing their approval. So you have two different tracks going. You have the actual operation of the property going by one individual, and then you have the applications being made here by the future operator, which will be BOLA.
But isn't the future operator the landlord?
Future operator is the owner right now, but they're probably, and I haven't had a chance to speak to them to vet this out with them, they're probably under a contractual arrangement that gives all the rights, interests of ownership to the current operator. So it maintains the responsibility on the current operator, the maintenance of the property in compliance with the board's rules. So that's probably where it's at. The current operator, the owner, BOLA, is anxious to improve the site. And once we get the approval now, they're ready to move ahead, and what's on the site right now will all be changed and
But that's not
eliminated.
going to happen for,
So if
2018, I don't know when.
Happen in the
lease-
next 3 months, he's chomping at the bit to open it up.
I thought
Chomping.
you said it's a
They're ready.
2018 lease. I mean, the deal is that the guy has to leave in 2018.
No, I don't know exactly what the exact specified date. I have to speak to him and
That's
verify.
what it said in the papers, that's
Right.
where I got 2018 from. But then on the other hand, what if you have a holdover tenant? What if we don't know when this is
I'll
gonna
speak
happen.
to Mr. Singh, he's the owner, BOLA, and we weren't able to speak to his office yesterday, we weren't able to get in touch with them. We'll get you the exact terms of their business relationship and where they are, but rest assured that BOLA, their business is not running stations like this, their business is demolishing them or
Right.
rebuilding them and modernizing them.
No, but, so the problem we have is, for all of these years, it was approved, this application was approved in 2014 with the board's understanding that the site would be improved, therefore didn't impose significant conditions,
Yes.
right? Because the whole thing was going to be done over, right? So in all of those years and prior to that, the site has been mismanaged. And so the board didn't realize that this was going to happen.
Well, it's not really that bad, by the way. I mean, I've looked at the pictures, I've gone by it. It's not a wreck. I mean, I don't like the landscaping they did out front with the cinder blocks. It's not exactly the best looking planter I've ever seen in my life, but they get an A for effort. At least they tried to build a planter. But it's not, I mean, the place is not riddled with, I mean, we've seen some disastrous
They selling
sites.
cars?
I don't know. I don't know what
Because
they
they had
got.
those 3 red cars in the.
I'm not representing, we're not,
Yeah,
this is the first I'm learning. In my mind, when we made this application, I wasn't looking at it from the angle that you're looking at it with the sins of the past. I was really looking at it that Mr. Singh is the new guy in town.
Well-
And for whatever the reason, the business relation deal went south 3 years ago and got stalled, but now he's cutting checks to everybody and signing papers and saying, go, go, go. So I have to assume he's ready to do his magic number, which on these gas stations, which as we've seen is beautiful in the
Right,
end.
but we're not going to see it done for a while, and then we don't know if the business relationship will
Well,
go
I'll find
south.
out. I see where you're going. You want to get
Right.
it cleaned up right now. I'll make sure, I'll try and find out if that could happen. I just don't know, I wasn't even getting in
I
touch
mean,
with them
it's
yesterday.
more like, I don't know what the business relationship is. Either BOLA is the landlord and then can enforce against their tenant.
They are the landlord.
And if they're the landlord, then they must enforce against their tenant to comply with the law. And the tenant is not in compliance with the law because apparently there are 17 vehicles, according to the last inspection by Commissioner Montanez, and the pavement's in bad shape, and it looks like they're selling automobiles and all that stuff.
Yeah, because I'm
right?
sure it's a previous operator like we've seen on all these gas stations. It's not a
Right.
company
Yeah,
like
but
BOLA.
This has been going on for a long time.
Yeah, I get where you're going. So let me
Right.
get you the assurances you need that everything is coming into place. Maybe I'll have some contracts or some paperwork I could show you. Maybe I'll have some good faith communications between the current owner and some other people to show you the efforts they're making to get you to the level that he's seriously moving ahead right now.
No, but it's not that he's seriously moving ahead
Right.
with his plan.
No, at the same time, I'll get him
He has to enforce
I'll get him
against
to clean up the
tenants.
site against,
Yes.
yes.
That's what we want to see. The next time you're here, we want to see the site complying with the terms of the
I
prior
will-
grant.
I will ask them to do that.
Which
and
we
find
should
out
have
what,
seen
if anything,
before, right?
you know, well,
We
yes,
thought they
but,
were doing a demo.
but we've had this before,
Right.
if you remember, we had 20412 Northern Boulevard, which is a British Petroleum station. If you remember, Community Board 11 had old junk cars, it's a Cadillac Eldorado, an old one that I kind of liked, out in the parking lot. And everybody was up in arms. Went to the community board, everybody was up in arms. If you recall, in that situation, British Petroleum was prohibited from the terms of their lease agreement with their tenant from going onto the property. So they actually had to get a court order to get onto the property to enforce the conditions that are on there. So I don't know if any of this is what's going on. I don't know if it's quite as simple. I know you're saying, you're the landlord, you can do whatever you want, but from
No,
my...
I'm not saying you can do whatever you want. The landlord's responsible.
Right.
Therefore, the landlord has to take care of it.
Right, but I don't think anybody was looking at it through your lenses until now. I think up until now, the lens that they were looking at it from is the site's going to be gone and we're going to get rid of this guy and we're going to clean it up. So your point is valid. We'll take care of it. Nobody was trying to avoid anything. I just don't know if we can move it at the speed that we would want to. I'll find out all the complexities and I'll let you know.
Okay, it shouldn't be that hard to take the vehicles off the lot. You just take
If
them
the
off
gentleman,
lot.
but as in 20412 Northern, we weren't allowed to do it. We had to get the sheriff.
So
In
then-
order to get the sheriff to do it, we had to go to court. So that was what we had to do there in a landlord tent.
Because then otherwise we end up having to turn this into a compliance hearing and bring that guy, whoever the operator is, in, right?
Well, you wouldn't want to
And-
do that for
I
Mr.
mean,
Singh.
By the way, we should have the owner here, the actual landlord should be here to hear this, so.
Oh, he'll hear
understand
it.
the
He's being sent a
seriousness
link
of
right after we
this.
leave.
Okay.
He'll be sent a link of this. So that way they clearly see, no, we'll make sure, we
Yeah,
understand
'cause
what you're trying to
As
do.
the landlord is in violation of the approvals at this moment, okay? Because we don't care about the tenants come and go.
It's not the case.
We'll make sure it's taken care of.
It's okay.
The other thing is, could you find out if there's any update on the widening of Victory Boulevard at this location?
At the what? Say
When
again?
we gave the original grant, there was discussion regarding the widening of Victory Boulevard.
Is it now?
We'll ask around.
It was in planning at the time.
We'll ask around, but we'll find out. I'm sure you're curious. We'll ask city planning if there's anything in the borough president's will.
Okay.
Okay, good. Are there any speakers in this? All right, so, so the main thing is, you have to come back right away, because we don't want to just drag this on, right? So what's the earliest we have available?
Do August 15th?
What I'm trying to avoid is the site is out of compliance. I don't want it to be continuing to be like that because people talking about paperwork, right? So is there a way we could put this on for something earlier, like in July? Maybe the 11th, because it's not long.
Well, we could do the special hearing, but
Yeah.
is that, I don't know if that's a meaningful
No,
time.
they're not.
Like,
so-
is that a meaningful gap for him to go back, have conversation? If he just comes back.
I can't
and says,
represent enough. I have one of the best,
the answers to
I have
your
one of the most,
questions. I just
good
don't
faith
want-
operators that I've ever represented.
I-
I have a really good client, so I will, they're serious. I mean, they have trucks that they distribute their own gasoline. I mean, this is a very serious enterprise. So I will get you all the answers for you, exactly what you need, and tell you. And if at that point the board feels like you want to bring a compliance action against the current owner, it's certainly within your discretion. But I'll get you all of the
The current owner is your client.
the current operator.
Well,
It-
no.
We'll get you- when nobody's
compliance
trying-
actions are brought against the owner
Well,
of the property.
The compliance action would just be a compliance hearing on the previous resolution. I mean, I know, yeah, we would be discussing the previous resolution, which
We're already
doing it
doing.
now.
Yes.
And, actually, these extensions are, in a way,
Right.
I'll defer to council.
Yeah.
There's a compliance aspect of
Yes,
this already.
right,
So,
right.
so,
Yeah, and we're going to come back to you with all the
Somewhat
information you
moves
need.
to
I mean,
a
we
certain-
just, nobody thought coming into this, I really didn't think, I got a guy that builds the nicest facilities in New York City. I mean, if you're going to take a gas station that everybody's saying is horrific, and you want to see something nice, this is the guy to facilitate to do it.
Yeah, but nobody's
So-
arguing that, but not if it takes place in 4 years.
Well, and
right?
that's what I'm trying to come back to you and tell you. So all this conversation we're having right now, I might be able to, he didn't take the call yesterday. We tried him 3 or 4
Okay, all
times,
right.
so.
So I would like to put it on for the 11th, so at least we can get.
If we could have it the
follow-up.
week
I don't
after,
want it to be
if it,
paper shuffling that holds
If we can do it
us
on-
finding out how to deal with
Yeah,
it.
yeah, the 11th.
we could do it on the
Okay.
18th, where everybody's out of town on the 11th. Everybody is out of
No,
town.
we can't.
No.
We can do the 11th, or we can do August
15th.
15th.
Yeah, that's a problem.
Well,
have-
we could have at least
So I-
come to the hearing on the
I
11th.
just don't want the 11th to not be useful. That's my concern, is that you'll come
It's-
back and you'll have half. the-
Honestly, aside from our vacation schedules, it's the week before, it's 10 days before 4th of July now, and it's going to, the 11th is the week after, and that 4th falls in the middle of the week.
So, yeah.
So it's going to
Alright.
be, listen, I'm trying to give you the assurances. I don't have, one of the clients that you're chasing around all the time.
Yeah, yeah.
He's-
But, okay, if we do it the 15th, please bring your client with you, and if possible, bring the operator.
August 15th?
Yeah, August, we can do it.
What date was that?
August
August 15th.
15th, bring your client and the operator.
And it's a July
26th.
July
26th.
26th submission of whatever
And
kind of
and we'll
documents.
we'll get answers, and then we'll try to give you the assurances. I understand, Madam Chair, that you're very concerned, and the board has been very concerned, made it a point to maintain sites.
Yeah.
So I'm sure there's a situation here that I'm not aware of, and I'll explain it to you once I get in touch. Thank you for giving us the time.
to be useful,
No.
you know?
Bring client and, so you're gonna bring the client and the operator, okay? And if you need our help in making sure the operator comes, we'll give it to you by like a formal letter from the city of New York to the operator.
I don't know if you need that. I think once Mr. Singh finds out what's occurring at one of his prized locations, he'll twist arms to make sure people are
Okay.
there.
Okay, good, thank you.
Thank you.
Item number 5, 34403 BZ, 2777 Flatbush Avenue.
Good morning, Chair, Commissioners. My name is Ariel Holzer from Goldman Harris. I represent the applicant, Nick's Lobster House. Sorry. this
Sorry,
is-
just okay, sorry, I'm sorry.
Sorry. I attended the executive session yesterday and heard the issues raised by the board. I had limited contact with the client yesterday, so unfortunately my answers will not be as comprehensive as I would like. And if the board would indulge me for a continued hearing date, I would like to answer in a more comprehensive written manner and respond in a more comprehensive manner to the board's issues. In terms of the questions raised, what I can answer, since August 2015, they've made slight repairs in order to be able to reopen the restaurant. They were suffering significant financial losses after Hurricane Sandy and the closure of the restaurant. They've made slight repairs in order to be able to reopen and operate, and they have been operating, but they haven't restored it to the manner in which was before, or to their plans, which they would like to do, but need a new lease with a longer term in order to receive funding. There's no C of O yet because, for main reason is also because they need the use special permit from the BSA before they would be able to get a C of O from the Department of Buildings. In terms of the signage issues raised, as the board noted that the compliance is vested in the SBA, which has actually given their authority over to the EDC in terms of this lease. EDC has not raised any issues with signage, and it appears that they have approved of the signage. The only objection that they have ever raised was that it needs the use special permit from the BSA.
My question is, does EDC have the authority?
Not
That's-
SBC.
SBA.
SBA.
SBA, apparently, from what I've been told, has passed their authority to
Past year,
EDC.
But either one,
Right.
they have the authority, whether it's SBA, Small Business Services, or EDC. Do they have,
Override.
do they have the override capacity?
I could answer
You
them.
need to find out more about this.
Yeah.
Obviously, you didn't have time, because how could a 400 square foot sign be allowed in this location, right?
Right.
So you need to find out whether they exercised override, or I don't know why they would do that for a sign, frankly, or what,
Right.
right?
In terms of the parking spaces, I believe was raised. My understanding is that 10 spaces have not been restored yet from after the Hurricane Sandy. So that's why there are 100 rather than 110. Again, I would like to give a more comprehensive and written answer to these issues, if the board would indulge me in that matter.
Okay. It's funny that you say, though, that EDC took over SBS. I don't really get that. Because literally, if you look on their website, they still claim authority for the waterfront properties that are city properties.
I understand. I believe what they've told my client is that it's an EDC lease, and they're leaving EDC in charge of compliance there.
Okay. Okay. All right. All right. Were there other questions that, because we, obviously, are there any speakers on this? Okay, so how much time do you,
I could submit on August 2nd for an August 22nd hearing date, if that's all right with the board.
does that work, Brian?
Yeah.
Yeah, okay. August 2nd for August 22nd, is fine.
Thank you very much.
I read it actually in one of these
Item
places,
num-
and I can't find which one it was.
Well, the next case?
Yeah, sorry.
Item number 6, 16404BZ, 2241 Westchester Avenue.
Good morning, Madam Chair, Commissioners. Joseph Gattiner on behalf of Moshe Friedman, PE. So we had someone here yesterday at the executive session. We appreciate that you mentioned that the client actually is applying for his extension as opposed to, you said many other people just don't do that. There were 8 open DOB applications. At the current time, there are only 2, and they're very close to being signed off, having some minor holdups at the Bronx DOB with those 2 applications, but they should be signed off in the near future.
Okay.
Besides for that, everything else, it has been taken care of.
So it's really, you're applying for an extension of time to obtain a C of O, but your permit, your PCE permit continues to be valid, so that's not a concern about that being expired. Okay. Are there any comments from the commissioners? No? Are there any speakers on this? Okay. So, all right, so I don't think there are any open issues. I just want to make sure, is fire department still here? Does fire department have any issues on this? No, okay. So I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Sorry. Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
And a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you very much.
Thank you.
Item number 7, 15908BZ, 6870 Spring Street, Manhattan.
Eric, before you start, I just want to make a note. Are there people here for the IFC theater? Only Paul, okay.
Oh, no. Stuart.
No, but people from, members of the public is really what I meant, as opposed to from the bar. Okay. They may be coming later. Okay, just check. Thank you. Now really cheap. Oh, I see.
Hi, Eric Palatnik.
Wait, this one.
Here today with our project architect. We're requesting an extension of time to secure complete construction and secure a certificate of occupancy. We attended your review session yesterday, and we heard what your comments were, and we wanted to respond to your comments.
Okay, sorry, we're like confused
okay.
again with collating. Does everybody have a copy? Copies of these?
Yep.
Okay.
So one of the documents you have in front of you is the DEP, is an asbestos report, excuse me, that shows you as one of your questions with regard to the asbestos work that's been done. So we wanted to alert you to that. We also wanted to talk to you about the DEP work. You had asked about the Phase 2 report. As you know, the last approval conditioned in a requirement that we submit to DEP and secure a notice of satisfaction from them, which we still intend to do. So we're not changing that condition within the resolution. We wanted to just alert you to the fact that at the time that we submitted the Phase 1, or the applicant did at the time, the Phase 1 report in the 2008 application, in that time, The Phase 1 report was very cursory. You know how Phase 1 reports are done. There's actually no testing done on site. They go through records and things to the like. Since then, we've had a much more thorough environmental reporting done on a Phase 1, which has come to the conclusion that no Phase 2 is required. And we could submit that to you. We are communicating right now with the DEP. Philip Habib and Associates has been retained to do that. So we're not asking this board, as part of this action, to change that condition in the resolution. There was a condition in the resolution that prior to any certificate of occupancy being issued by the New York City Department of Buildings, that DEP shall issue a notice of satisfaction. And we still intend to secure that notice of satisfaction in accordance with the board's resolution, so we're not seeking to change that.
But whether or not there's a Phase 2 required is up to the DEP.
It's up to the DEP.
So you don't know that yet, for sure.
No, correct, but again, we're not asking the board to opine on that at all. We will comply, as is in the resolution, that we secure a notice, a sign-off from DEP, a notice of satisfaction. That's the last sentence within the resolution, that the applicant shall secure.
Well, that should be forthcoming very shortly, correct?
Philip Habib is working on that. We don't know how soon it could happen. It could happen in a month, it could happen in 2 months.
You don't have the report submitted to DEP yet?
The report has been submitted to DEP. Philip Habib is following up on it right now.
So-
But DEP in the summer, so we don't know.
I mean, DEP did ask us to sort of hold off pending this.
Yeah.
So, I mean, if this is, I don't know, there are
Maybe-
other issues, but if this is the only outstanding issue, we can give them time to work
Yeah.
this through. I understand that.
We can go back to DEP and find out, speak to Philip Habib and find out what's
Yeah,
going on. But,
yeah.
you know, I'm hoping that the board will at least buy into the last one of the 1, 2, 3, 4, 5, the last, that clause, really put the burden on DOB, not on the board.
Sure.
And it clearly says that no temporary or permanent C of O shall be issued by DOB or until DEP issues a notice of no objection. So
Right.
I'm not trying to say the board shouldn't hold us here, but we're begging you to not hold us here because we have a lot of money at stake, we have huge commitments at stake, and we are required under the purview of the resolution that was issued before to go to DOB and show them, so DEP is protected. I think they're trying to do belts and suspenders by making sure it's resolved here.
Right, but you also have a time to complete that expires October 28th of 2017. So we have a little leeway here
Yes,
to get DEP.
true, we won't get kicked out, that's true. I didn't realize that, you're
Sure.
right.
So,
So we
yeah.
won't get kicked out of the DOB filing process.
Right.
Permitting process right away. But as we start to tick closer to September and the Jewish holidays and Labor Day and everything like that.
So you're going to work
get a little concerned.
fast around
Well,
those
no, but
things?
that's my point. That's my point. I'm asking the board to recognize that workaround and everything like that is extra in addition to what really we should be required to do. So if we do end up getting caught up in a rigmarole, there's already,
But we can cross that when we
get there,
sometime
yes.
in
I'm hoping you're just
September,
sympathetic to where they are, because
Right.
there's bank commitments, I mean, there's a lot going on, we're juggling a lot of individual pieces.
Right.
But
So-
also, as a I would recommend as a courtesy to DEP, who's asked us to sort of.
And we're happy to extend the courtesy, I just don't want to
I
end
just
up in
wanna make
September
sure
where
that-
the board may take a difference of
Understood.
opinion, and then our client has a real problem.
Right,
So,
okay.
but we could certainly float for the next month while we figure it out.
Okay, good. So, and then there was also a question, there's an architect's certification that makes reference to a proposed modification to change the configuration of the penthouse.
Right, so, and Bill is here, and he's going to talk to you and explain
Okay.
everything to you.
That's not part of the application.
That's not part of the application. The application, as you know, is a use variance. Up.
Okay. Okay.
So Bill is going to come up and speak, but the essence of what he's going to suggest to you is that he's been working with the Department of Buildings for a substantial period of time. They just recently secured a sign-off from the Department of Buildings on the plans that you now have in front of you. The job originally was approved by the board as a use variance, so Department of Buildings has signed off on everything so far, and Bill is going to explain to you what the changes are, because he's been the one handling them, and he's been meeting with DOB, and why don't you come up, Bill?
Please state your name for the record.
My name is William Bialowski. I'm the architect for 6870 Spring Street. We've been working for a number of months with the DOB on plans submitted, and at this point we have 2 small boxes left to check before a permit would be released for us. One is receiving our sewer and plumbing connection, SD1, SD2 is how it's referred to. That was submitted months ago. We're just waiting on that agency. And the final box to check is this DEP box. Until the DEP box is checked, we will not be able to begin any construction on the site. As far as changes in the plans, the DOB has been reviewing our dimensional adjustments as of right adjustments. Everything is fitting within our envelopes. The adjustments that are in the handout to you are pretty de minimis. They are mostly driven by a very small change to the lot configuration. We had what's referred to as a GORE on our site, which is a piece of the lot that belonged to us, but that was not in our title, was not in the meets and bounds. And so if you look on that very first page, you'll see a little triangle. That little triangle caused us to adjust the back of the building ever so slightly. Oh, it's on the top page, on the first page, this little triangle on the back.
The approved stamp.
This little piece of square footage, when we realized it really was ours, allowed us to adjust the rear wall of the building ever so slightly. So you see rear wall adjustments, understanding where our 30-foot setback is, came from accommodating the GORE. The second adjustments at the top of the building, where we had to reproportion the penthouse configuration so that we could create a public terrace, not a public terrace, but the quality housing terrace that's required for the tenants in the building. In the design that we submitted to BSA, if you go to page, let's say the proposed 8th floor, what we submitted to BSA was that the plan that sort of chopped the whole penthouse in half, the whole roof in half. We could not get any elevator and handicap access to a public terrace through that process, and we desperately want to build a quality housing project, so we just had to reconfigure the square footage so that we could create a terrace for the quality housing.
Well, wait a second, but the interior of this is a new unit upstairs.
No, we have the same number of units as we applied for. There is just 1 duplex, not 2 duplexes. That's the difference.
So, okay, so, because I don't want to get into this, because this is an extension of time to complete application, right? This is an amendment to the variance?
No, the DOB has reviewed all of this as of right. It fits within the building envelope, and the variance was solely for use. Everything else that has been presented to the DOB is as of
That's not how
right.
the board reviews projects. If it's a use variance, it looks at the massing of the building. And, yeah, it looks at the massing of the building, and if it decides that the massing doesn't fit within neighborhood character, that's one. Or if it decides that there are more units than necessary to make a reasonable return on investment, that's another.
Yeah, we've not, Madam Chair, we've not added any units.
No, I know, but I don't want to, I don't want to have the amendment hearing here because this is an application to extend, but I think that you need to come back, you need to at least have a meeting with staff to talk about, or you need to have a meeting to at least talk about an amendment.
There's a change.
Well, we're not stamping new plans, right?
Yeah, we're not
we can't. We're not stamping new plans.
So they have to build.
DOB was of the, I understand what Madam Chair is saying, of course, you know, there's that old saying, you know, it's the BSA approved plan, it's the BSA approved plan. But of course, DOB has within their discretion to determine if the plans are in substantial compliance with the board's approval. And they do have a modicum of discretion. And Bill has been working with DOB for some time, that everybody is very well aware that it's a board case. The examiners he's working with are very well experienced. And we have to have some confidence in Department of Buildings that they reviewed it. They were aware it's a board case. They have the discretion. It was a use variance. It's lower in height. It's a use variance and lower in height. that's enough, in my view, if Department of Buildings determined that it's
All right.
compliant.
I don't want to have this
but-
debate here. So this is something where you have to make an appointment to meet with staff and discuss whether or not this requires an amendment to the drawings. Either, I don't see it, but either a letter of substantial compliance or an amendment to the application, because the drawings have to be amended. The project's supposed to be built in compliance with the drawings. That's the
That's fair
condition
enough.
to
If
approval.
that's fair enough. Your point is fair. Nobody's saying it's not. It's not that we didn't think about this before we came in here and talk about it. That's why we're telling you that DOB just approved it. One of the ideas that you just mentioned, which we would be fully amenable to, is submitting an amendment by letter and asking for an amendment by
Well,
letter. if
that's
that
what
was
I'm
the board.
saying. We're not going to negotiate which one it is. You're going to meet with staff and discuss what's the appropriate route.
Fair enough.
Okay, so that kind of changes everything, because an extension of time to complete is based on the approved drawings of the original variance, because we don't issue new drawings for an extension of time to complete. And if there are changes to the drawings, you're supposed to advise us, right? So here we are now advised, and.
Or, that's one perspective. The other perspective is that Department of Buildings has determined that the plans are in there's plenty of approvals. There are plenty of buildings in New York
I
City,
heard you
just
about
so
it.
we could defend the point and just talk a little bit on it. There are many buildings in New York City that are under Board of Standards and Appeals approval, that when they got to the permitting phase, the Department of Buildings has allowed for modifications to those plans and for the buildings to be constructed, and they've determined them to be in substantial compliance. All we're positing here to you, and we understand you might have a different perspective on it, is that we believe that Department of Buildings did that. And as soon as we got the approval, which was from the Department of Buildings about 3 weeks ago, we had the hearing scheduled, so that's why we're alerting you now. It's not like we've had the approval for a year. So we are trying to act in good faith. We're not here asking you to accept something that Department of Buildings didn't fully vet and accept, nor is it different than what they've done. I'm sure if you've prosecuted cases yourselves here, I'm sure if you've gone back to all of the applications you've prosecuted and look at the buildings, there's some changes.
So let's just say we have a lot of experience here with the Department of Buildings missing things that were
Well, why
done
don't
by
you-
the BSA, and then it never came back here, and it should have done, and then we end up having to deal with it
Understood,
after the
understood,
fact,
but we're gonna
okay?
clarify that.
So just to finish this, so you're gonna make an appointment to meet with staff to discuss what this is?
Right, but
Okay?
can you just clarify with your
Well,
interaction?
in our review with the Department of Buildings, the review was based on the use, the variance was for use only. Everything else is well
So
within and
that's the
smaller.
DOB's interpretation of what it is that we do here, but it isn't actually. Once you have
Well-
use, then massing isn't regulated by zoning if it's a use variance, right? So it's regulated by the board determining whether it meets with.
But we still complied
neighborhood
with the mass for that
Right.
site.
Well, okay. All right. So any comments from board members? Are there any speakers on this? Okay. So we'll still continue with the DEP issue. And in the meantime, as soon as possible, make an appointment with staff.
We'll make an appointment with staff, and if we could come back to meet with you on July 25th.
So I don't know about August anymore. Is August 15th still available, or August 22nd?
The 15th or the 22nd are fine.
Okay, I don't know if the 15th is enough, because you're trying to make progress on the DEP approval. So
What date is that?
the 15th of August or the 22nd of August?
The 15th of August is okay, but the DEP approval, I'm sure, that, again, we're hoping you're going to take the position that your approval did require that that Department of Buildings not issue a C of O before the DEP issues a notice of
No.
satisfaction.
No.
So we're going to
no,
try.
No, actually, what we said was that DEP asked that it receive a copy of the Phase 2. If you're going to talk DEP out of the need for a Phase 2, then it seems like that's faster than actually
Yes.
preparing a Phase 2. So
Right.
perhaps you'll succeed in that by the next time you come. And if you do succeed, then DEP is ready effectively to sign off, right?
Yes,
But if
we're
they're
hoping.
not, then they're going to say, no, you need a Phase 2, and then we can talk about the timing to prepare your Phase 2 work plan. and then where that puts us in the October, whatever date that was.
October 21st.
October 28th, end of
28th.
October, where you're up against that kind of
That's,
deadline,
see,
right?
that seems like that'll work, and we'll meet with the staff in between. And we apologize if we caught you off guard. All Bill was trying to explain to the board too, though, is that the, whatever changes there were, perhaps why DOB looked at it that way, is everything the building got smaller. The massing of the building didn't increase, it actually shrunk. So the number of dwelling units shrunk, and the height shrunk.
And we're not
So-
gonna
I know, but
talk
that's just to
about
let you know where
whether it's,
DOB might have been looking at it from.
Okay, so is the 22nd good?
Of August?
I don't know if that's really enough time for you.
No, that's, I'm out of town the last 2 weeks, the 15th would be great.
Okay, but I just don't know if that's enough time for you to get what you need done with DEP.
We
at
have
that point.
confidence in Phil Habib.
Okay, August 15th then, for August 2nd submission, no, sorry, August 22nd, July 22nd submission.
That's what I figured.
Sorry, 26th submission.
Thank you.
Yeah.
Thank you for your time.
Okay. Appeals calendar, am I calling both or just the best? Both?
Both together.
Appeals calendar, continued hearing items. Item number 8, 16612A, and item number 9, 10713A, 638 East 11th Street, Manhattan.
Good morning, Madam Chair, Commissioners. Marvin Mitzner, the applicant.
Good morning. Before you start, I wanted to just add some more information from after yesterday's review session. So after yesterday's review session, council and I looked at some additional case law. And, you know, the question is really, was the permit validly issued, right? That's the first part of the question. And the second part of the question is, if it was validly issued, then was it relied upon in good faith? So there's this really interesting case, the matter of 9th and 10th Street, which is a Court of Appeals case decided in 2008, where there was a kind of an interesting situation where a building was built that was claimed to be used for dormitory purposes. But the court determined that using it for dormitory purposes was not practicable. It says, but whereas here officials reasonably fear, speaking about the buildings department, that the legal use proposed for a building will prove impracticable, it is not improper for the agency to insist on a showing that the applicant can actually do what it says it will do. And so in that case, the Court of Appeals determined that the impracticability invalidated the permit. So when I looked at the originally approved drawings from, whatever that was, 2004, I looked at the drawings to try to understand how that was going to be medical offices. And I got a better set of the drawings subsequently than I was looking at before. And I could see that each of those units that were supposed to be medical offices, and as I say, I have a lot of experience designing medical offices, each of the units that were supposedly designed for medical offices had the layout of something that looked like a kitchen with a sink. Now, medical offices always have a cabinetry and a sink. But as the building inspector pointed out, they also had dishwashers. There's only one dishwasher ever in a medical office to wash vials and things like that, which you don't really use anymore. So I didn't understand why you would need a dishwasher in those units. In addition to which, the units had two-piece bathrooms that were designed with a 3x6 open area adjacent to the toilet, in which was drawn a line that said shelving. And the inspector noted in the inspection document that the shelving had not been installed, so he wrote, remove indication of shelving from the plans. And having been to a lot of buildings in places like Bushwick, where in an M district, I've been in artist lofts or artist studios, and the studio is equipped with, an artist studio in an M district, the studio is equipped with a kitchen, which, you know, artists need to eat while they're working during the day, and a two-piece bathroom with an unusual 3-by-6 area next to the sink or the toilet, which if you just simply knock your hand on the wall at about 5 feet off the ground, you will find the shower body. So it was pretty obvious to me that the drawings in this case, the 2004 drawings, were actually designed for a different purpose. So the other part of it is, if I look at this court case of 9th and 10th Street, and I see the issue of practicability. If those units could have practically been used for medical offices, they would have been. There would have been some indication in the history that we've seen since 2009 of an attempt to rent them for medical offices or actually using them as medical offices, and then maybe they don't work out or something, but they never were used as medical offices. From the very start, they were used for residential purposes. So it seems to me that consistent with in the matter of 9th and 10th Street, we've got a case where the permit seems to have been invalid on the basis of impracticability supported by this 2008 Court of Appeals case. The other aspect is that we have a vesting application, and one of the vesting findings is that the applicant relied in good faith on the permit. So if the applicant never intended to use the space in the way that it was represented on the drawings for medical offices, then how is that good faith reliance? In fact, it's bad faith, because not only was it occupied from the beginning illegally, but during all the time that the board directed the applicant to cure the illegal use, it chose not to do that. So the application's been here since 2013, and in 4 years, there's still illegal occupancy to this day of the units. So, you know, just to kind of cut to the chase there, I'm now believing that we don't have a valid permit, therefore there was no vesting. I don't know what the other commissioners think, but it was very informative to learn about this new case. And on that, I hand it to you.
I hear what you're saying, and a lot of that is based upon supposition and surmise on your part. And I presume I will have an opportunity to respond and indicate the errors of what you're presuming and support the application. I presume I'll have that opportunity.
Okay?
Okay.
Is there anything else you want to?
Well, the fact is that there was an inspection that was done last week, and it established that the rear building was vacant, that one of the 3 units in the back of the front building was vacant, and we gave you a schedule as to when the other 2 will be vacated.
So there are 2 that are still illegally occupied.
That's correct.
So 4 years later, we still have illegal occupancy, right?
Well, the fact is that the owner is now attempting to remove the tenancies.
Right. But 4 years ago, the owner was also asked to remove the tenants, and that's a lot of tenants later. I suspect that a lot of those tenants are not the original tenants.
But again,
Right.
that I understand that. That's an enforcement issue, but that doesn't speak to the basis of this application. Both applications. The one application was the application by DOB to revoke the C of O, which, as I will remind the board, was predicated initially upon the supposition that the foundations for the rear building were not completed,
Right.
and based upon a misreading of a statement by the engineer, which was corrected, because the reference that he made in his letter about foundation work referred to the front building and not the back building. The back building's foundations were complete. Notwithstanding that we believe we have a statutory right to vesting, we did present evidence on substantial reliance. So I believe we have 2 bases upon which we can claim vested rights. Okay? The other issue is again, we submitted support for the vested rights argument under common law, which is the second case that's pending before your board. As I said earlier, you have now indicated an inclination on your part in terms of how you interpret the case, and I'd like an opportunity to respond and indicate that there is, of course, our view of how this case should be looked at, and we'll support it in the best way we can.
Okay, all right. Commissioners, want to?
The only thing I wanted to add is originally in the 2004 plans, the front units were also medical office, correct?
Yes, I'm aware of that.
Right, so you have approved plans to show that now they're residential, but I don't believe they were also ever occupied as medical offices, according to our understanding from people from the community.
Okay, I'm aware of that, but we'll present our evidence as to what occurred in 2004 and what the intention was thereafter.
I'm looking at the approved plans, the 2005 set. You know, the other thing that affected my thinking was that in 2011, I guess sort of after there was a lot of attention being focused on this project, the architect submitted a proposal to convert the use of the back building and those rear-facing units on the cellar level and cellar and first floor to dormitory use, which I find interesting because they never could have been used for dormitory use, but that was consistent completely with the layout of the units, where now you see the bathtubs in place, you see the kitchen with all of its fixtures and so on. But they never could have been dormitories because you're not allowed to have sleeping accommodations in one of those permitted obstruction buildings. You're never allowed to, even prior to the change in the zoning. So that just sort of draws more attention to the reality that using this for residential use was always contemplated.
Once again, that's just your supposition, and we'll present some evidence to the contrary.
Okay, it's not, so impracticability is a big issue because it seems to have been proven because it's impractical to use it that way. Plus, just to reiterate from yesterday, the changes that are required by the Department of Buildings to make this legal medical use are enormous. And unfortunately, the courts have ruled, because I don't agree with them, but they're the courts, so they get to decide, right, that there isn't sort of almost anything that's not a curable error. So even though you need to install fire corridors and remove all the partitions and almost all of the toilet rooms, bathrooms that are in the addition to make that one continuous medical space, which I cannot imagine is ever going to be used as medical offices because you're not allowed to install doors. So how does a doctor function in a place where there's no doors between the spaces unless they put the doors in, which would be illegal because it obstructs egress. So I look at that layout as almost less practical or practicable than all of those little tiny rooms, which are also not practicable because, again, the doctor had no receptionist, no place to have the doctor's desk versus the exam area. I mean, I can't imagine it.
We have had these plans audited by DOB, and as a result of that audit, we have made revisions to those plans, which create significant, but they create a practical medical office in the rear building. And DOB has not objected to that at this point. So that's what we're prepared to do, and those plans have gone through extensive audit and been approved as modified.
So let's just say to color that, DOB has allowed for changes that make the use on paper legal. In other words, there's egress that's required now, which was the main change that was made, right? There's the removal of all those kitchens and bathrooms, which were clear indications of residential occupancy, right? So that the plans are, let's say, bad designs is not something that DOB looks at, right? But practicability, which was what the Court of Appeals looked at in the dormitory case, is something that we can.
Well, we'll examine the
look
case,
at.
but I think it's a little presumptuous to say that this board can come to a conclusion that they don't believe that these medical offices are practicable. When you have all sorts of different medical offices throughout the city and throughout the country, either they are a grouping of small suites, or they're larger areas that are subdivided. There's a whole panoply of different types of spaces that can be used for medical facilities.
Right, so I'm just going to read one other really nice quote from that case. It says, "It would create needless problems," because we talk about the enforcement problem that this back building has presented to DOB and the elected officials and the community since the building was occupied in 2009. The court says, "It would create needless problems if petitioner built a 19-story building only to find that it could not use it in a legally permitted way. The city would then face a choice between waiving the legal restrictions and requiring the building to remain vacant or be torn down." So,
Well,
there you go.
this is not a 19-story building.
No, it isn't. It's a two and a half
It's a small,
story
rare,
building.
it's a small, rare
Right, that
building,
is
right.
causing all
Right.
kinds of difficulties. So
Well-
19 stories causes more difficulties maybe than 2, but nevertheless.
And
Okay.
that may make a difference.
Okay. All right, any other questions, comments? All right, are there any speakers on this, DOB? Please.
Well,
Yeah, of course, DOB first.
the council member and
Yeah. Well, actually, maybe, because you have to leave? Or will you stay for the whole thing?
we want to hear.
Okay, so let's hear DOB first.
Good morning, Madam Chair. Commissioners, Andrew Wallace, Assistant General Counsel, Department of Buildings. I did attend yesterday's executive session, and did not appear to be any questions directly addressed to the buildings.
No.
As it was stated yesterday, we did inspect the premises on last Thursday, accompanied with Mr. Mitzner, and we're in agreement that all of the units in the rear building have been vacated. One of the units, the duplex units in the front building has been vacated, and the other 2 remain occupied. I guess, Mr. Mitzner, council reiterates their contention that the foundations were complete and that they're statutory, vest statutorily. The department, as has been our position all along, takes strong objection to that, and that's been well documented in our submission, so I won't waste the board's time with them here. I must admit I'm not familiar with the case that the chair cited, but certainly will review it. I don't know if there's anything else for the department to comment on at this time, but happy to take any questions.
I don't know, I don't have any. Anybody? Questions? No, thank you.
Thank you very much.
Council member?
Thank you very much, Commissioners. Chair, I am Rosie Mendez. I am the councilwoman who represents this area for the last 11 and a half years. I also live on the block. So I just want to reiterate a couple of things. Back in 2005, I saw Mack trucks delivering lots of mattresses and microwaves and dishwashers. There was a dentist's office across the street on the north side of this building. It had a sign stating it was a dental office. I would see people coming in and out. At this building, I have never seen people coming in and out. There's never been any signage to indicate this is a medical office. And I saw the review session yesterday, so I want to reiterate, there's always only been one entrance to this building. I think it was mentioned that a separate entrance would be needed, and I've encountered that problem on another project.
We checked, it's not needed unless it's on the second floor.
Oh, okay. I also noted that the board had requested that the architect submit a affidavit. He had submitted a letter that was not authorized or notarized or whatever is needed, and so I don't know if that's been submitted as well. Looking forward to seeing that. So my experience up until also Saturday when I walked past the building, there's 4 apartments in the front that there are 4 windows that you can kind of see into. 2 of them are kind of frosted, and those seem to be all occupied as well. And I have some pictures, which I did not develop to print in time to bring here, but I could submit those to the board later.
That's of the front.
Of the front 4, yes, because I cannot get a view to the back without going into.
But I believe that the front units can legally be occupied as residential. It's the rear units that face the 2-story structure that can't be because they don't have adequate distance between legally required windows and a wall.
But I think that was due to the rezoning.
Yes.
Right.
No,
But
no.
In 2004, they were not.
No, in 2000, right, in 2004, no, sorry. At no point could they have been, those back units at the first
Okay.
and cellar level been occupied for residential use because at no point was there the legally required distance between windows because of the back building. If there were no back building, the first floor unit could have been occupied for residential, and the cellar could be used for like a rec room because you're not supposed to sleep in a cellar.
Those units were depicted as
As
medical office.
yes,
correct?
and the drawings were
On the
depicted
drawings,
as
yeah,
medical
okay.
as they could be legally in that configuration with the back building facing the
But also,
windows.
in 2004 plans, the front units were also medical office.
Were also medical.
And then when the
Yeah.
zoning changed in 2008 to an R8B, I believe they could increase the residential FAR.
Oh, I see.
And then, that's my understanding.
Okay. The other issue I would raise is I do not believe any of those units that could be apartments in the front meet the requirements of the law that it has to be 400 square feet or larger.
Oh, that's another subject.
The other thing I want to bring up is when we saw all this happening in 2005, my neighbors and I did believe that this was going to be used as dormitory rooms. And, you know, whether they were or they weren't, we were always checking with DOB to see if a 10-year lease as required, as referred to as the dormitory rule, but RCNY Section 5101, and there was never any lease signed with and filed with DOB with the educational institution.
Right, but that rule didn't come into effect until March of 2005. So, because we checked that yesterday.
Yes, you may be right.
So in 2004, assuming the plans were legally issued and assuming they had vested, et cetera, they wouldn't have been required at that time to have a lease for a dormitory, but it doesn't really matter because they never could have had dormitories back there for other zoning reasons, not for code reasons.
So if the apartments were rented, or the micro units rented in late 2005 and early 2006, it would not require compliance with the dormitory
Also,
rule?
but that's a different thing. So if then subsequent to the change in the rules, where there was a March 2005 rule requiring a lease with an institution, an educational institution, then they wouldn't have been able to change the use of the front units without providing a lease, right? So So they needed to have done that, and DOB would have needed to see a copy of the lease, because they, as you know, enforced that very intensively.
And the last thing I just want to say is, once I got into office in 2006, I would meet with DOB regularly on a variety of issues throughout my district. This was one of the buildings that I used to bring up. And at the time, they had a TC of O. The then Manhattan Commissioner had told me, we won't issue a C of O until we get an inspection, because they had not been able to get an inspection. Somewhere along the line, the C of O was issued. When I met with the Manhattan Commissioner, he was totally unaware of it. I don't know what resulted from that afterward. All I know is that the C of O was issued, and top level individuals at DOB were not aware that that had happened. That is all.
Thank you very much.
Thank you.
For coming. Any other speakers on this? Please,
Greenwich Village.
Hello. Thank you for the opportunity to speak to you today. I'm speaking on behalf of Greenwich Village Society for Historic Preservation, the largest membership organization in Greenwich Village, East Village, and NoHo.
What's your name?
Gabriel
Gabriel what?
Hidalgo.
Hidalgo, okay.
Yeah, sorry about that. So the agenda posted online indicated this item was scheduled for decision. The January hearing on this matter was not changed our position on this item. We still believe that ample evidence has been provided that this building has never been occupied fully in conformance with its certificate of occupancy. That is, given its current occupants, the building does not conform to zoning, either the old zoning or the new zoning. As commissioners noted yesterday, the architects did not provide the stamped affidavit as requested to clarify the intention of the applicant from the very beginning. Clearly, what we're opposed to the doctor's office for which this building received the additional community facility bulk allowance from the former R7-2 zoning were occupied exclusively as residential apartments. As was noted before, even after the terrible tragedy of Hurricane Sandy, when rebuilding offered the applicant an opportunity to conform to the community facility requirement, this was ignored. At yesterday's executive session, the commissioners indicated your recent site visit shows this residential use is still occurring. It remains unacceptable for developers in building large buildings based upon false contentions about the occupancy of the building. This is a serious and ongoing problem, especially in the East Village, and it needs to be addressed by all relevant agencies and entities, including the Department of Buildings and the Board of Standards and Appeals. We support the contention of Councilmember Rosie Mendez that this building is a violation of the law and its current occupant should not be allowed to continue.
Thank you. Thank you very much. Are there any other speakers? Yeah. No other speakers? Okay. So I would actually like to give council on both sides an opportunity to respond to comments today and each other's comments and the public's comments. But I would like to close the hearing so that the next session will be a decision. And we will review the materials that are submitted and make our decision based on those materials, okay? So, yeah?
Are we closing the C of O case?
No, no, so,
So just closing on the vesting?
It's an interesting question. So I want to just say, because we talked about something yesterday. So if the board votes to grant vesting, we would leave the C of O revocation application open so that in the event the applicant doesn't make all the required modifications, you don't have to bring the case back, the case is already here. In the event that the board decides that vesting did not occur, then it's kind of irrelevant in terms of the C of O, because vesting didn't occur, therefore the C of O is invalid, therefore the board can vote on the C of O the same time. So I'm just wondering what we should do there. Do we close the C of O and leave it?
You could always reopen.
Yeah, okay, so what we'll do is we'll close both of them, but we won't bring the C of O let's say, if the board votes to vest, then it won't make a decision on the C of O action until much later, sometime later, right, okay? Understood? Just for ease of the applications following each other
So,
along.
let me just ask one question. If they
Yeah.
don't vest, then they have to modify the current plans that are at DOB.
No, they have to modify, it. If they don't vest.
Yes. No?
That means they didn't vest under the then
The
zoning.
rear yard,
Right, so if, assuming that because I'm not sure, it's been so long, right? Assuming that the only issue about compliance with zoning is the structure in the rear, and that otherwise the building complies with zoning, which it of course would more do because it has less floor area, right? But I'm not 100% sure if just removing the back building cures everything.
They would have to comply with the new
New
zoning.
zoning,
well,
right.
we
Relatively
probably should know what that is.
Yes, right, so we should know, that might be somewhere in the,
Well, maybe I don't know if DOB ever looked at that. If they didn't vest, what would be, the permitted building?
yeah.
I can research that, but it would seem to be that would have to be under the current zoning.
Yeah, yes.
Yeah, it would be under current zoning.
Right. So that's a question, would removal of the back building be adequate to bring it into compliance? Right, or, because there still is, I believe, a community facility, so-called bonus in that neighborhood?
No,
I think it's,
No, it's
It's
an as-of-right use under the same FAR.
Yeah, yes.
So it doesn't
Council's correct
improve
on
the
that.
FAR then?
It just-
Okay, so what we also need from both is information about what would happen if the vesting was not granted. So what would be required of the building to bring it into compliance with current zoning? Okay? Okay.
So closing the C of O revocation case, I think
We
may...
didn't vote on it, we just closed
Okay.
it, right?
The
And we can
record's still
always-
open.
Yeah.
in
The
terms of-
record's still open on both of these cases, right? And we can always reopen if we need to reopen, right? Okay. So then I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
I'm sorry. Commissioner Montanez?
Aye.
And Commissioner Brown?
Aye. Okay. And then set the briefing schedule, basically, right? So where are we? How much time do you need? Because we're going to add DOB's time, and then you can have a SIR reply if you want it, right? So,
Unfortunately, I'll be away for most of July, so I'd like to put it over to August sometime.
okay, so that you would submit when in August?
Mid-August sometime.
August, what?
Current configuration of the board
Ooh,
goes away.
you're right. Wow. What to do about that? How do we do brief? We only have, sorry, just a second, we have
Sure.
a quorum issue.
Yeah.
4 weeks. 3 weeks, really. Do we just say, oh, well?
No, there's, what is three?
Or
Yeah, I
three,
mean, we
we
still
might
have a
just say,
quorum.
oh,
Still
well.
quorum.
We still have
Yeah.
a quorum then, and we might have another board member.
Yeah, right, who has to start all over again.
Well, we
Correct.
would probably want to
Abstain.
abstain.
Yeah. Okay, we just have discussion, okay. All right, we're going to have to keep it on that schedule. I don't know how to do it otherwise they don't have an opportunity to respond to
Yeah.
the new analysis, okay? So, okay. All right, so August 15th then, is that for your submission, Mr. Mistner?
That's fine.
Yeah, and then DOB gets 2 weeks, 3 weeks? What do they get? 2? Is 2 weeks enough?
I'm actually going to be away the last 2 weeks of August, beginning of Monday the 21st.
Okay.
After Labor Day.
Okay, so you can't submit until the end of September kind of thing?
No, that's 2 weeks.
Yeah, but he's away, but he's only going to receive a copy of the materials on August 15th. Yeah. So what does that mean? So how about if you submit it on September 13th?
If I could get to the 22nd, that would be helpful.
Say that again?
Yeah, August 22nd. Still gives buildings about a month.
Yeah, they're not
Yeah.
pushed.
Okay.
That's fine.
Okay, let's start again. You submit August 22nd, building submits
September 13th.
September 13th.
Okay.
Is that good? And then do you want a SIR reply?
Yes, please.
So a week of that, so September 20th? And we need, because we also have the hearing schedule, so.
I'll be
So-
away the last week of September also.
Okay, so that works then, September 20th.
I think so.
So September 20th for your reply, because you only have a week, right? And then 1, 2, so then October 17th is the hearing.
October
What about
17th.
DOB, sir, replying?
No, there's no such thing as those.
I'm sorry, that's right.
It's only
Sorry.
the vesting.
Sorry.
And
That's right.
everybody's away.
There's only one SIR in this
And
group.
the October 17th.
Sorry,
Yeah.
that's right.
So it's an October 17th hearing. And in the meantime.
A decision.
Decision, yeah. And in the meantime, I expect, of course, to see those other 2 units empty.
We'll keep the board updated.
Yes.
That means you're going to have them empty.
That's what an update means.
That's not what it's meant in the past.
What's that?
Okay.
And the department as well.
Okay, thank you very much. Oh, actually, since we have you, so like we did the last time, if the department could arrange for an inspection prior to that hearing, so, yeah, prior to the October 17th hearing, so let's say like a late September inspection.
There's a doctor's office in there, by the way.
Oh,
Yes, sure.
We can all go. Yeah, sure. Okay, yeah, you'll do that.
September.
Okay, great.
Do you want to
Thank
coordinate
you.
with the board? Is that-
Say again? Yeah, so some of the, at least 2 commissioners will attend. Okay,
So,
maybe others. Okay,
all right, so we'll coordinate together. Let me know.
great. Thank you very much.
Thank you.
Ready to move on?
Yeah.
New cases, item number 10, 19-12A, 3830 28th Street, Queens.
Where you got, are you
Uh, Good almost afternoon, Madam Chair, Commissioners, Marvin Mitzner for the applicant. I think the board at the exec session asked why we need 2 years.
Right.
Well, and my understanding is the extension speaks as of the date that it expired, so 2 years brings us to October 2018. I don't think we need 2 years, but 1 year would only bring us to October 2017, which is kind of a short period of time for us to make certain we can get the C of O. Which is the only reason why we've asked for 2 years.
I see, because it's a standard. Okay. So, but what is left to do?
We need Con Ed to step in, which they've been sort of,
Con Ed hookups are already in place according to the status report.
we don't have Con Ed service. And we don't have,
You have gas service but not electric? Is
yeah,
that
I
what the
believe so,
issue?
yeah.
You don't know which
I
one?
spoke to the owner just yesterday. There are only 3 items remaining.
Okay,
One is the ARC fire system that has to be installed and tested. Secondly is the generator, which has to be installed and fueled up. And then there's the Con Ed final service. That shouldn't take too long, so we're not talking about a lot of time, but as I said, to leave us till October of 2017 to do that and get the C of O
Yeah.
is kind of short.
right, okay, understand. All right, any other comments? Are there any speakers on this? All right, so I'd like to make a motion to close.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Montanez,
Aye.
Commissioner Clifford.
Aye.
And a motion to grant.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Montanez,
Aye.
Commissioner Clifford.
Aye.
Okay, thank you.
Thank you.
Zoning calendar, item number 11, 2016-4249 BZ, 2420 Amsterdam Avenue, Manhattan.
Good afternoon, Jeff Mulligan, Camera 11 for Young Wu and Associates.
So, yeah, you want to say anything? No? So I think we have everything we need. So I would, and I don't think there were really, one of the things I wanted to just ask commissioners, the community board had talked about dedication of 5% of the office space to community-based organizations. I don't know that we need to get involved in that. It's more like a deal that they made, because they talked about labor issues and stuff like that also. Okay. All right.
I think we
Go ahead.
discussed just referencing that, sort of that memorandum of understanding in like the resolution. Obviously we can't condition.
Just that, right,
But
okay,
we'll
so we'll just make
reference it, that
in the
community board.
resolution, we'll refer to that the community board had a memorandum of understanding, but we won't include those in our
Right.
conditions. Okay. All right, so on that note, a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Hinkson? Oh, Jesus Christ. Vice Chair Chanda, it's not my day today. Vice Chair Chanda? Aye. Commissioner Montanez?
Aye.
Commissioner Oakley Brown?
Aye.
Sorry about that.
Thank you.
That is respect.
Thanks.
Continued hearing items. Continued hearing items, item number 12, 17414 BZ, 820 East 182nd Street.
Okay, they wanted to adjourn this. I don't know if there's anybody here for that. No. Okay, they wanted to adjourn, so the nearest, closest one we have is August 22nd. So that would be a submission August 2nd. And they don't get to tell us which days they're taking off on vacation.
Item number 13, 317 14 BZ, 3780 3860 Nostrand Avenue, Brooklyn.
Morning. C.B. Mobley, Brian Cave for the applicant. Thank you, commissioners. I attended the executive session yesterday and I heard your concerns. I wanted to start off by addressing them specifically with regard to the rear yard improvements.
Sorry, can you speak
move the
up,
mic,
or
sure.
maybe,
Move the mic up.
yeah, you can hold it in your hand if it's too uncomfortable, but it's hard to hear you. Maybe, is the AC still on?
I turned it off.
It's
the
off,
outside.
okay, it's the outside, sorry, it's
I'll
because there's a
project,
truck
I'll project
outside.
more.
Okay.
So I wanted to start with the rear yard improvements that you discussed yesterday. First up, the guardrail. We understood your concern in wanting to have it extend the full length of the rear yard, and so we will ensure that that happens. Just so you understand, the original thought was to only have it where there was adequate space for the cars to back up, so that it protected the fences, and not to have it where there was more of a driveway area. But we'll extend it, that's not a problem.
Okay.
With regard to fencing, I'd like to introduce Dennis Noskin. He's the architect of record for this project. He'll talk you through the fence that we propose to use and maybe some other alternatives, and let's see if we can get to a place where we can agree on what fence to move forward with. Thank you.
Madam Chair and Commissioners, I have a...
State your name, please.
My name is Dennis Noskin. I'm the architect of record. And I have a handout to pass out about different alternatives for fencing for this back rear area.
Okay.
Thanks.
How much extra we can give it to Tony? So.
Little survey of the fence.
We,
Fence 101.
Fence 101,
Okay.
Chairperson, I went through the internet, I looked up all the alternatives there were for fencing that seemed kind of practical. There's some advantage to disadvantage behind all. Just to tell you the highlights on it. There's PVC fencing, which looks kind of cheap and it gets kind of brittle over time. When a vehicle hits it, it will crack and fall apart. There's wood fencing also that comes in all sorts of different fashions. Similar to the PVC fencing, it also is vulnerable to dumpsters, trucks, and anything that might back into it. It also will fall apart. The only one that has the most amount of flexibility on it, unfortunately, is a chain link fence, which is there now. A chain link fence, of course, when you back into it, if you don't
What
hit
about
it.
the iron fencing we don't like?
Well, the iron fence, then you get a permanent kind of kink on it, and then it's a hard one to replace.
It also doesn't provide screening.
It doesn't
Well,
provide
it doesn't
screening.
provide screening in this Google search.
In this Google search. But the chain link fence back there is kind of the most flexible. Obviously, it's a fabric, it bends, it moves a little bit. The privacy slats in there, which will be now black, will blank out the area. But the one thing I also want to point out to that site is there's kind of a hedges and a large amount of growth, as well as a lot of the neighbors have another fence that's beyond this fence, providing the screening. And we haven't heard anything from the neighbors regarding
There
the
is
current
another
fencing.
fence, I'm sorry,
Yeah,
there's
second.
another fence behind the...
Not
chain?
all of them, but most of them have another fence that faces off on theirs. So.
I mean, this is kind of, they fence it because they don't want to see this use, right? So they're protecting themselves from the use because the use isn't making it a desirable.
That's correct, and we don't
right?
mind seeing their use. I guess they mind seeing ours.
Theirs are gardens and barbecues.
They'll
So,
also say that it allows the owners to control their own use. So they can pick their fencing, they can pick their landscaping,
true.
they can see what they can see.
That's true.
so the one that we specified after going through the Google search was one that was similar to this one, which is a chain link fence. It'll be a new fence with new slats. It'll look nice and pristine that first day. As it shows on our original drawings, we are putting in that guardrail, which would be about that high
Right.
in there, and it's really the only alternative that makes sense.
So the thing is, the fences that you've shown, again, because they're from Google, right, aren't taking into account the fact that this fence gets a lot of physical, horizontal pressure placed on it by the cars backing into it, the dumpsters rolling against it, et cetera. So my comment yesterday was, if you're going to use chain link, which, and you know, what I always talk about slats, I'm sorry they were invented because they're made out of PVC and that's not a nice material.
I'm not a fan of them either.
Yeah, so, but independent of that, the fence gives so much that it gets crumpled, right? And so the photographs that we've seen of the rear show the fence in a pretty much collapsed form, right? So in order to prevent it from getting, from collapsing each time someone smashes against it, you need more frequent vertical and maybe even a horizontal member to protect it.
The guardrail will be extended an entire front of it, so that's
only at a bumper height, right?
It's a little bit higher than bumper height, yes.
So then, I'm not sure what other things are causing the collapse, but maybe if you had more frequent vertical and maybe a horizontal member, which you do sometimes see on Google when you search it.
I guess if you're looking for it, you could find it.
Okay.
You could find anything on Google.
Right.
The one thing I just want to call to your attention is that fence has been there quite a while, and hasn't been really maintained. And
Right.
I'm not saying that this new fence will be maintained any better, but
Correct.
I'm guessing it's gone through maybe 20 years' worth of abuse.
Yeah. So arguably, we're not going to see it again, right? So what we're trying to do is, since people aren't really paying attention to this rear, to make sure that at least it withstands as much pressure as we can get it to withstand. So,
I think so. About the additional rails, the horizontals, I have seen the horizontals on other fences. I'm not going to deny that they're. I think giving the fabric of the fencing the most flexibility is the best way to handle it. If we put a crossbar in there at another, let's say, intermediate length, like maybe here, I just think that's the opportunity for them to hit that as well. So it's kind of,
what do you mean it's the opportunity to hit that?
if there was an intermediate rail, like here,
Yeah?
on something, if it wasn't there and you hit it, it could sort of bounce back. If it's there and it's rigid and you hit it, it kinks.
I think your plan would be to put it behind the fence.
Yeah.
On the
Behind the fence.
back
Yeah,
side
behind
of
the-
the fence.
right.
Same thing, as then it's a permanent bend versus the fabric, which can sort of come back.
But, wait a minute, but so the whole idea is to keep the fence from collapsing. If the fence is being hit so often.
We don't know how often it's hit, because
Yeah.
it's 20 years worth.
I have a question. the guardrail is going to be in front of this fence.
Yes.
It's on drawing
Right.
3B.
And where is it mostly, I mean, the height of the guardrail, is that adequate for it to be, for any impact?
Most vehicles will stop when they hit it. You know,
And does that further affect the change? I mean, what is the gap that will?
well, let's say it was a roll-off dumpster,
Right.
and it rolled, you know, those dumpsters are about this high, and they're usually slanted, could hit that chain link fence.
The dumpsters are hitting them, that's clear from the photograph. There's 3 dumpsters lined up, and that's where the fence is completely collapsed, and the dumpsters are this, so they roll and they smash, right? So,
Or any
I'm not a
truck.
I'm not a dumpster.
truck.
Any
I'm not a
truck with
dumpster
a
expert,
bed
by the way.
above the rail
Right.
will hit the
Yes.
fence too.
so I'm not hearing a good solution yet. So, maybe what you should do is, maybe what you should do is talk to somebody as opposed to going to Google. Go talk to some fencing people
We
and tell
did.
them what your problem is.
We spoke to Gun Hill Fencing, we got a proposal from them for both the guardrail and the different variations.
Right.
Some of the stuff I looked at was on their own website. If it pleases the board here, we can put a horizontal member, which will stiffen that, say midsection across there, and we'll
But it horizontal only works if you've got enough vertical, otherwise it tips, right? So that's, you know, and sometimes you also see them diagonal. I don't know why sometimes you see them diagonal or horizontal, but there's a, right, so, but you can see that the purpose of it is to make sure that the fence is intact after impact and doesn't look like this after.
Well, one thing is the guardrail does not extend, right now, does not extend the entire way, and that would definitely
Right.
help the preservation of the
But
fence.
that won't work with the dumpsters. The dumpsters are deeper than the guardrail at a higher
Well,
height.
they sort of come
Yes,
convex.
exactly, so that's not gonna work for the dumpsters.
So I have a question. Instead of, so are you suggesting this horizontal thing being part of the chain link fence, or could it be an extension of the guardrail? So you have guardrail, 2
Yeah, it could.
parallel guardrails. Can that be structured maybe?
Guardrail obviously could be in front of the fence and at any height,
At
if
any
that's
height.
what the idea is.
Would you like me to extend that guardrail at another height where the dumpsters are located right now, rather than the whole
I
thing?
mean,
'Cause
I'm trying not to be the designer of the system. There are systems for this,
I'm
so,
trying,
right?
I wasn't here at executive
Yeah,
session
yeah.
yesterday, I'm just trying to come up with solutions.
Right, I understand, but, so you're trying to come up with solutions on the fly, and I don't
I only,
think that's good.
I only had 12 hours.
So, yeah, no, so that's the thing, and I don't believe in design on the fly, even for a fence. So I think you had the problem, and I think there's a good design solution for it. But, by the way, we had other issues, so you can integrate that with the other subjects that we would talk about, so we get sort of an integrated whole. It's both kind of decorative, if we want to use that word, for plastic slatting. It shields the neighbors, and it also prevents it's also built with real integrity to prevent it from collapsing over the years, okay?
I just wanted to define collapsing. It really hasn't, collapsing means it's sort of like, it's
No.
down. This is sort of like,
Collapsing is this, when you look at a fence, you think of this. When you look at the fence and there's a picture that looks like that, I would call that a collapsed fence.
all right. I would call it undulating, maybe bending.
Undulating, there you go. So unless it's an undulating design, which you're welcome to try, either it starts vertical and stays vertical, or it starts undulating, and, you know, that's a design decision.
I mean, I see that the owner is very eager to sort of, you know, select and install a fence to the satisfaction of the board, so.
Right.
Is there a way we can sort of move this forward by coming up with a proposal and submitting it to you, or without waiting for the next hearing, so that we
Well,
can?
we might be able to do this fast, so let's just see, because we have other issues. So
Okay,
let's see
okay.
what the other.
So the next issue we wanted to talk about was landscaping.
Right.
I know that was something that the board was very interested in understanding, whether there was the potential for landscaping in the backyard. Dennis Noskin also prepared a submittal that you've received. And he concluded there wasn't, so I wanted him to speak to that and talk you through that, okay?
Okay, we looked at that back area, and we looked at the vehicles coming through that back drive, and the way the parking was lined up according to meeting the parking requirements. And as much as I looked at it, and there's one or two trees back there right now, there's no place to put additional plantings. I know that in executive session, you talked about possibly putting in porous pavers and maybe having some sort of ivy or pachysandra climb up that famous chain link fence or whatever fence we pick. But candidly, Chairman, there's no room. There's vehicular traffic comes by there. A lot of them are trucks or, for the most part, step vans, and there's barely enough clearance to accommodate that now. I mean, I think that the pavers or porous paving would get torn up with the wheels of the trucks turning on it, and
No, okay, maybe you misunderstood what we were getting at. I'm just looking at the photograph that you provided with your drawing about the guardrail. So that was
3B?
03B, right?
Yep.
So that one has a photograph showing a guardrail in front of the fence, and growing on it is ivy, right? So I was just thinking, when someone else raised, I think it was Commissioner Shonda raised the porous paver idea, that along the fence, you install porous pavers, which will give a purchase for vine planting. That's it. And so there aren't actually any wheels that are gonna go there because, right, that's the guardrail is supposed to stop your bumper, not, right? And your wheels can't go between the bumper, between the guardrail and that.
so you're saying right on I just want to
Yeah,
get this
right against the, right
on-
against the fence, a line of porous pavers that have soil underneath that allow you to plant vines, and then the vines can crawl up and hide the nasty slatting.
What's the thickness of that?
The problem is I have this, it's not really a curb, it's more like a foundation wall that runs there that's about a foot thick. So I don't know how to get that soil, any kind of penetration on that. If you look carefully at the pictures, like on drawing 1 and also on 3B, you can see that the fence comes down with the slats and everything like that. There's concrete underneath there. There's no soiled area. You know, it kind of reminds me of a famous thing, a comparison between an architect and a doctor, where doctors always bury their patients, and Frank Lloyd Wright said, well, all an architect could do is plant vines.
Vines, that's what we're trying to do,
I know.
plant vines.
And believe me, I'm not saying this chain link or whatever we pick or design isn't ugly, but I don't know how to get the vines out of the concrete.
No, well, that's because, just a second, so,
The vines are really coming from the property behind it.
yeah, that I get, but, so for example, if you were to cut the concrete, just like 8 inches or 12 inches along in front of your curb, I'm looking at your section, 8 inches along your section that's on 3B.
Yep.
Okay, so your guardrail, I see somehow, not sure how it's mounted frankly, but anyway, you have a guardrail that is sitting on top of the curb, right? And I actually don't know what its purchase is, but anyway. So, and you have that little slope there. What if you cut the concrete at that spot and you put pavers? They can even be slope pavers if there's some reason for them sloping there. And underneath that, you dig a little trench, and the trench has soil, which doesn't have to necessarily be continuous because you don't need that much soil. So every X number of feet, you create a little trench thing, and in the trench, you plant vines, and the whole idea is to just make this not such a terrible looking place. I mean,
Well, that would reduce the driving
no,
width.
no, it wouldn't because they're permeable pavers. All you're trying to do is give, so you can actually drive on them.
Right, but if you're going to put a permeable paver down that can also be a driving surface, you need a certain kind of base material. you know, something
Like gravel.
compacted to us, yes.
Right.
Which I don't think, to me, is not really amenable to plantings. Otherwise, it's going to sink.
That's,
What you're talking about is putting that paver down right here.
yeah.
And I'm saying when a guy comes with his wheels, he's gonna, that's a wheel, for lack of a better word, he's gonna
Because the
turn on.
guardrail's actually closer.
You're saying the vines
to
are
the
caught like
fence.
that.
So the photograph doesn't show the guardrail as close to the fence as your detail. But is it? Like, where's the,
I hate to say it, but it kind of varies, where sometimes it's in the concrete, sometimes it's in front of the concrete.
the guardrail, right? Sometimes you have vertical support in front of the, so I was, based on other photographs, assuming that your guardrail is supported by, in front of the curb. Because other photographs show it in front of the curb.
Some of them do, yeah.
So, that, I guess that's my question, I don't really get it.
If it was like this, let's say chairperson, you know, like just in front, and we got a vine that ran behind it like that, and crawled
Yeah.
up the fence.
Yeah, so actually, some of your photographs don't show the guardrail sitting in the curb. It shows the guardrail sitting at the level of the driveway.
You mean
Yeah.
like that?
That's the section that I was assuming was the case.
Okay.
In which case, you could have planting in between the vertical supports, because there would be no driving on it.
That's a few inches.
Yeah, you don't need much.
6 inches. maybe.
Yeah,
So this would be a 6-inch paver over here?
yeah, essentially.
And in that case, I don't really do too much as far as the design of this fence, which you're not going to see it over time.
That you're not gonna what?
You're not going to see it over time.
Correct. But you still need to prevent it from collapsing when hit by a car or a truck or a dumpster. Right?
Okay?
Okay? All right.
It's doable, expense.
Great. So, and then the other question was about, oh, you want to go on to the next?
Does it make sense to sort of wrap up what you want us to do as far as the fence and the landscape? Because those are sort of
Right.
their own
So
separate
the
thing.
fence, I'm not sure that it's like, again, I don't want to design the structure for the fence right here and like negotiate whether it should be a horizontal or a diagonal or whatever. I don't know the answer because it's supposed to withstand impact, right?
Understood.
So, okay.
Can we make a separate submission? Do we need to wait to come back to hearing
Yeah,
for
no,
this?
so
Well,
you
how
would
can
make
we
a
work?
submission,
Fine.
we'll wrap this up at the
Okay,
end.
okay, okay.
So now we go to the question of the parking.
Let's move to the parking garage, okay. So I'd like to start off with an apology because the parking signage memo made reference to constraints on signage that were not adequately explained. So I heard that you had that question yesterday about the owner
Oh,
and
ownership, yeah.
the zoning and the DOT constraints. And so I thought we would start off by just explaining where, like, the location of the signage, why it was limited to just the facade of the parking garage. So first up, I'd like to introduce John Swaggerty. He's a representative of the owner, Senior Vice President, Development and Asset Management at Acadia Realty Trust. He's going to talk about the limitations that are created by the lease for each individual unit within this shopping center, and why each lease grants each tenant their exclusive right to using their facade. So, John?
Hello, my name is John Swaggerty, Senior Vice President for Development and Asset Management at Acadia Realty Trust. We are the owner of the property in question. The issue here is about signage on and where garage signage can be placed on the building, in response to a question about if that garage signage could be placed on a corner building. And the quick answer is that the tenant that occupies that corner building is a bank that has been operating the property before our ownership, subject to a long-term lease on the property. We are told that it's been there since the 1970s. That lease allows the bank to have exclusive rights, exclusive control over its facade, and meaning that they do not have to accommodate any other signage on their facade other than their own. So the lease also is long-term. It has another 10 or 15 years plus options. So it would be difficult, if not impossible, for us to make this request to the tenant when it's not currently part of the transaction. But further, sort of speaking to the market conditions of this kind of shopping center, shopping strip, it is fairly typical for a tenant to control their premises, especially in a single level single-level, single-tenant commercial building where, in the boroughs, they would expect to have full control over their facade and only have their own signage posted on that.
Okay, I have a couple questions.
Okay.
First, don't patrons of this bank have the right to park in the parking lot?
Sure.
So isn't the parking provided for the bank's convenience as part of its tenants' scope of
Yeah,
the lease?
the parking is provided for the convenience of all the tenants.
Okay, but specifically this bank?
Sure.
Right? Okay. So the second thing is, doesn't your lease include the right of the landlord to do certain things on the property when required to by law?
That is typical language in leases, yes.
Okay, so if the board requires that you install a parking sign that is actually there for the benefit of the customers of the bank, then that would be a requirement by law, and you could just say, here we are, we have to do it, we don't have a choice, it says so right here in section 21 of the lease, right?
Yep, that is something that has been done in the past. Tenants, you can imagine that tenants have different reaction to it, even to language on their own lease.
Right, okay. Good.
We can run through the other constraints, DOT and zoning constraints if you'd like to. Do you want to hear those as well?
Sure.
Okay.
Yeah.
With regards to the zoning, James Colgate, who's a partner of Brian Cave, but also a former deputy commissioner of DOB, is going to address that.
We know.
Good afternoon, Madam Chair and Commissioners. So, with respect to the zoning resolution, the Buildings Department has been interpreting and enforcing a directive from 1967, it's Directive 38 of 67, with respect to signage and how it's allocated across a multi-tenant property. All the practitioners, architects deal with this, have dealt with it. It says something in the zoning. The Department of Buildings wrote something very different in that directive, and then that directive has been interpreted over time to be rather strictly enforced to basically mete out and allocate signage across a multi-tenant streetscape. And this, I think you know the bulletin I'm talking about, where it says that each establishment is considered its own zoning lot, so that the bank on the corner is considered a zoning lot, this one is a zoning lot. Now, you have something unusual here. You have an establishment which is 15 feet wide and has two pieces to it, 30 feet, whatever that is, and that establishment actually helps all the properties in the block. So one could make an argument, but I know from experience, having worked at the Department of Buildings, that once the different applications, as has been done here, start to, I have this much square footage, I have this much square footage, and I have 15, I have 30 feet of frontage, I have 40 feet of frontage, and you fill out those signs, the department is very obdurate, can I use that word? Very difficult to change from that. The bulletin seems to afford a flexibility, but when you get to the department and get to the examiners, at least to the borough commissioner level, it's almost impossible to get anything other than looking at each piece as a separate part. So when you start to say, I want to put a sign somewhere else, the first several people we spoke to, the consultants, all said, well, that's not going to be deemed to be an accessory, that's going to be deemed advertising. And look, of course it's not advertising, it's on the same zoning lot, and it's getting you parking for the people on the whole thing. But that's the mindset that's in everybody's head since this bulletin in 1967. So I'm telling you there's a practical reality to trying to get an approval here from the Department of Buildings for anything other than signage in the location where it is. Now, we can try, fight, do that, but I'm saying it's extraordinarily difficult.
I have faith in your persuasive skills, and the fact that this is totally accessory to, if we're talking about the bank,
Yeah.
it's totally accessory to the bank use, because how in the world do I get into the bank unless I park my car?
That's right. I mean, the bank has is a one-story building, and they want to maintain their stature and look. We are the bank. This is us. This is our building, and they don't, you know.
And we offer parking to our patrons.
Which would be great if anybody wanted parking in this location.
And they will, because it's going to be free.
With all due respect, absolutely, it will be great, but you can't, if you build it, they won't come if there's lots of street parking. That's really why we're here to begin with. There's so much street parking that the people who even work for Acadia who go to visit this, have never had to actually go in the garage because there's always street parking. That's the reality, right in front of every store. But anyway, so let's go through the zoning issue. So that's the first zoning issue. The other, well, it's more of a code issue. It had to do with a remark that was made yesterday at the session where it said, well, could we put something onto the sidewalk to demarcate or indicate or direct attention to? The difficulty with that suggestion is that in order to do that, because it's under DOT jurisdiction, if you have anything other than a 5x5 concrete gray square, you know what has to happen. You have to go to the Public Design Commission. And in my experience, the Public Design Commission doesn't approve things for commercial direction to establishments. What they do on occasion is commemorative or historical things, or they'll let you, instead of do it square, diagonal, or maybe they'll let you change the
Color.
Well,
They could let you change the colors.
for the purpose of directing attention to a commercial establishment, I think that will be hard pressed to expect us to expect an approval for that, is what I would say. So I'd say humbly that that's unreasonable if it's a condition that we require something like that, because it's very hard to get distinctive sidewalks approved for any purpose. Even if it's to commemorate something important, it's still very hard to get, is what I'll say. And I think that's my role, right? Any questions on those two issues?
No, that's my experience with the sidewalks also. That's, I think, why people use those projections. And I don't know what DOB thinks about the projections, but that's why they use them.
Which projections?
You know, there's a light projection and there's like Batman down there.
Oh, that's a sign, that's an unlawful sign.
Yeah, but in other words, that's why people use them, because you just could switch it off and say, what sign?
Yeah, but with all due...
Something that would be more effective in the evening, and most of the shoppings have been during the daytime, so that's probably not good.
It wouldn't work, but also our client, Acadia Realty Trust, they don't do illegal signs. You will remember the images of this shopping center when they purchased it compared to the ones now. It's night and day. It's absolutely beautiful. Every sign is permitted and pretty, and the whole facades, all the buildings are better. They take their pride in making it done right, and they don't do illegal signs on the sidewalk.
No, I'm not suggesting it. I'm just saying that's the reason that you see those projected signs is because it's so hard to get approval for distinctive sidewalks. That's
right. It is. I mean, if we could put projected images all over the sidewalks and it was lawful and permitted, every retailer would do that. It's just that it's not lawful. It's a problem.
Okay.
Or maybe it's a good thing, but okay.
The memo also made reference to DOT constraints to the extent that there is a desire to put signs anywhere else on the street.
I think
okay, you got it.
it's just an idea, and thanks for clarifying the hurdles one has to go through.
Moving on to the operation of the parking garage, we thought it might be helpful just to review the most recent history of it. I'm going to ask John Swaggerty to come back up because Acadia Realty Trust took the property over a couple years ago. Prior to that, it had been in the possession of an owner. The parking garage was closed for a number of years because they could not find an operator to come in and open it and operate it. This was something that Acadia Realty Trust, you just heard James say, when they take properties over, they want to operate them properly in compliance with the requirements. The C of O specifies that this is an operational parking garage that needed to be attended. So Acadia Realty Trust, it took them over a year to locate an operator that was willing to come in and operate this parking garage because of the extremely low volume. So I want John just to speak to that one.
Yeah, just to reiterate, when we acquired the center a couple of years ago, the parking garages were closed. They were not open to the public. We identified that was a requirement of the approvals in place, and so we looked for an operator to operate that garage. It was difficult given the size of the garage, given the abundance of parking on the street and what's perceived as low demand for that garage. We did find one. We have someone who's there operating it now. But again, because of the low demand for the garage spaces, that operates at a deficit. That garage operates at a deficit every month with the attendant in place. That operator sets market rates for what the rates for parking should be based on what they perceive to be market, what they perceive to be a compensation for their services, and a discount against street parking for longer distance or longer durations park.
Say that again. What about a discount taken?
So I think this has been distributed in the past. If you look at,
To again, remind you,
Yep.
this belongs to
yeah, so for a 1 hour of parking on the street versus the garage, it's going to be more expensive on the street. But for longer term parking, the garage offers a discount on an hourly rate as compared to a metered parking on the street.
Which is how you would expect it to operate. The people want to get in and out, they're on the street, but for longer term parking, they can go down to the parking garage. And then they're discounted below the hourly rate of street parking.
But can you park there for 1 hour in the garage?
Sure.
Yeah.
How much, and for 1 hour, it costs
$1.50.
$3.
$3. See, you
For
don't
2
get-
hours,
That's
right.
the
Oh, that's
problem.
the minimum?
So what if, okay, let's just say for arguments, is everything metered parking that's immediately around there?
Well, across the street, there's another shopping center that has free parking at surface within the property lines of the center.
There's a large parking garage.
That has free parking?
Yes, there's
Yeah.
free parking.
Yeah.
But
And it's supposed to
they
be
need
for
their parking for their.
Yeah, exactly. It's supposed to be for
commercial
them.
uses.
It's supposed to be for them for practical purposes. We hear that people walk across the
Right.
street.
They also
So,
can monitor us.
right. So it seems to me that at the very least, you can't charge more for the people who are patrons of the operation than the metered parking, right? Otherwise, why would anybody ever park in that lot? No reason at all.
Well, for longer term.
Yeah, for longer term.
No, but
For the safe.
You have to go feed and meter.
for-
The
yeah.
street is designed for 1 hour maximum parking. You know,
Right.
The parking garage is for longer term parking.
got it, but
The
so.
convenience of a longer term, for not having to feed the meter, for the security of having your garage, your
But
car
obviously,
garage.
most of the shopping that goes on here is not 2 hour parking, it's 1 hour parking. Or you always think you're only gonna be there for an hour, and then it turns out you're not, so you have to send like your kid to go feed the meter or whatever,
Well,
right?
I actually think there's a large number of medical offices in this complex, and I think the people that are visiting medical offices are more likely to use the parking garage.
But so then why isn't the parking garage heavily utilized? If there's a lot of medical offices, it's because why should I? It's free at the supermarket
street,
across the
yeah.
street.
Well, and down the side streets as well, the avenues have free parking down the neighborhoods.
Right, so what's happening is, because don't forget, one of the reasons, the reason you're here is for a special permit to reduce the parking. So you don't just get to do that, right? You have to make some kind of an effort to ensure that the parking spaces that are on site are actually utilized. Otherwise, you're forcing more demand on the street. So you're rendering your parking garage kind of useless, and it's almost intentional in a certain way, not that, in a certain way, because you're observing that the supermarket that's free gets filled up with people because it's free, naturally. That's obviously where everyone would go. Words on the street, it's a free parking lot, right? So the idea that you have an operator, I mean, these are more like contractual arrangements, business arrangements that you make, but your operator reasonably has to be expecting to make some kind of a return. But you're the owner coming in to ask for a parking waiver when you built the building, or maybe whoever, your predecessor in interest built the building and when they shouldn't have, and increased the required amount, the required demand, right? So something has to give here.
While also increasing the income they could get.
And increasing the income.
And so maybe the owner needs to make a concession given that. And figure out a way to subsidize the parking to the operator.
Right, and I understand that you couldn't go back to your tenants and say, from now on, you guys have to cover the parking and it's going to be free when you hand out a voucher, because they would never hand out a voucher, right?
Right.
So it really is that the owner and the parking operator have to work something out.
Because there's the general findings, which are neighborhood issues, that, it's not going to be a detriment to the neighborhood. So if you're just pushing the parking demand out onto the street, so it makes it more difficult for people living in the neighborhood to park, instead of, utilizing your parking garage to its fullest, that's not in the spirit of the special permit.
I will note that this has been a long-standing condition, and we're seeking to legalize the existing condition. This is not something new. We're not looking to reduce the existing parking there. This has been in effect for a long time. And as I said, the parking garage closed for a many number of years under the previous owner. And we went out and we did a very detailed parking study, and we did counts, and there is more than adequate street parking right now. It's not, we're not pushing cars out onto the street, and there's nowhere to park, and people are circling the block. You can go there almost any time of day and find empty spots on the meters right in front of the facility.
Right, but so the thing is that we do a study, right? And the study looks first at the demand, and it looks to see whether or not the demand is met within the garage. But if the demand is actually met in the garage, in other words, the math and the studies show it's met inside the garage, then the expectation is that it will be used, right? Not that it will impose some kind of impediment that then ends up putting that demand on the street. So we never issue special permits for these kinds of things where demand isn't met on site. So how do we meet demand on site if we're seeing that the garage is empty most of the time, right? So that's why ownership has to step up and realize that if they want the special permit, they're going to have to make some concessions to this.
I will say that the parking study, looked at the existing demand, and then projected it at full tenanted occupancy. And the only shortfall was on weekends when the parking garage is currently closed because of the attendant requirement. So if the parking garage was to be made self-service, the expectation is that whatever shortfall in the demand might exist under heavier occupancy of the facility, that would then be met. And it's not clear to us that it's really about pricing. There's also a whole aspect of inconvenience that's created when the parking garage has an attendant. Many people don't want to deal with the person. They're concerned about having to tip somebody. And the operators wanted to make this a self-parking facility for a while because they feel like that would help increase the use.
What's blocking you from making it self-service now? Oh, you're just saying that the prior...
No, the C of O requires the facility be attended.
Oh, okay.
Right. So an aspect of this application is to reduce the number of spaces in the garage and allow it to be self-parking.
Right. So then you take away that concern about the valet being intimidating or whatever, right?
Exactly, and it would take away, people view that as being inconvenient, not to like deal with somebody, get out of their car or whatever.
But we also know, because we know us, we know everybody, offer me $3 versus no dollars. I go for the no dollars, I could spend $3 on half of a cup of coffee, for example, right? Right.
I just want to add one thing. I will take that cup of coffee. Commissioner Montanez raised a point which I think is important. As an attended facility, because of the square feet per car and the larger number of cars in there, that's bound by the C of O. If you make it self-park, you can't have the same number of cars. You have to reduce it in order to make it self-park, because otherwise you can't maneuver.
Understood.
So
Right.
so that's that part. The other thing that I think is important to understand is that the arrangement now is that the parking operator is leased the space with a subsidy, of course, but then the parking operator collects all the money from anything that they rent. So it's in their interest to price it so that people utilize it. If the operator overprices it, they make no money. If they underprice it, they can't make money. So there's an equilibrium in the middle, and basically, I mean, the market forces kind of help make it used.
Well, not exactly, because the operator must charge, right? Because the owner is not giving them any kind of a concession, right? So they must charge. So
Yeah, but if they charge
maybe
50 cents and they rent out all the spaces versus $1 and half the spaces, I mean, there's
But a lot of the spaces are long-term storage with car covers and antiques. That's the way it's being used currently.
Okay.
Which is
So-
not really the intention of the garage.
There's still a lot of empty spaces, but I understand it. I understand.
All right, so anything else you want to
If there are other things that you'd like us to address, we're glad to, but those were the issues we wanted to run through.
Okay.
from
Are there
yesterday.
any other comments before we go to the public, if there is any? Are there any public speakers? No. Okay. So then, let's go through what we need. Okay, so we are going to need drawings that amend to show the guardrail extending all the way through, right? Drawings of a fence design that withstands impact. The detail should show that little strip of paver that goes underneath the guardrail. The idea is not that you drive on a little paver, but it's underneath the guardrail, into which can be where there's a trench and soil, and planting can be planted in there for vines to crawl up the chain link fence, which I assume was going to be a chain link fence with vinyl slats. Then in terms of the signage for the parking, you should be going to DOB to get, or Mr. Colgate to persuade DOB that the signs on the corner that indicates parking is visible. If it's the bank corner, and that means the owner negotiating with the bank, that's their story. And then, of course, I don't see how we can do it anyway. Otherwise, I think the board's going to condition approval on the parking being free to the patrons of the establishment, and through the use of vouchers or however. Okay.
Completely free? Or free for an short increment of time? Have you?
For the patrons, right?
Free-
So if
so
I go
free-
in and I buy a coffee and I get a
Free
voucher.
parking all day long?
So you're requiring...
If you're going to speak, you have to come up. Yeah, okay. All right, so I don't
It
know.
seems reasonable that if there'd be a time limit.
Yes.
Like 1 or 2 hours.
1 or 2 hours.
Yeah, 2 hours
2
worth
hour
of free
limit.
parking.
I would just note that for the board, that otherwise you're making it, cheaper,
Yeah, yeah.
like the curbside parking that's right outside. I mean.
Right,
you know,
Right,
Okay.
but that's what we're trying to do.
I mean, I understand,
Okay.
within reason.
Right. Go ahead.
I would caution against, there is a thing called induced demand, that if you suddenly make this free and then you also reduce the requirement, that we might
Reduce-
overshoot. Like
What do you mean reduce the requirement?
We're reducing the requirement
Parking
for the
requirement.
parking requirement. That's what
Right.
the action is.
No,
And
but we
then-
looked at demand, right? And the demand is for patrons. That's how it was calculated. How many people go to these shops?
Sure.
And go to the medical offices? And
Sure.
based on surveys, DOT-based
But
data.
people are making their decisions now about whether or not they drive to this facility based on the fact that there is a $3 charge for parking, and
There's
they
also
may,
an enormous neighborhood use of this
and-
facility.
and, yeah, they may be,
No, I'm sorry. They're not making that decision. The parking utilization rates were determined based on standards, DOT standards for how many people come to retail and how many people come to medical offices, not how many people come to this medical office or this retail. So that the amount of the users for the specific actual on-site uses haven't changed. And if you give somebody a voucher because they've walked into the store, so they parked there, the only way that they're going to be able to stay there for an hour or 2 hours, whatever it is if they go into the store and they get their voucher validated. That means they've made a purchase, or whatever the store decides is the validation criteria, right? So that's a lot of trouble as opposed to being on the street. So if I'm not interested in shopping in that store, I'm not going to go park in that lot, go to the store, get a voucher, and then go to the place that I really want to go to, which is across the street. I just don't think that's human nature. Right, it's different than having it be free all the time and you park there for hours and hours and all that sort of stuff.
there's a lot of research into parking demand, and this is actually something that pricing and elasticity is something that is studied and is specific to sites, and that changing that may have unintended consequences that the board is not considering right now.
Right.
And
Well,
so
except for-
I would be cautious with the, let's make the parking free when it's not free now.
But it,
We're also
never
very
been
concerned.
analyzed based on a chart. We have other ones where the parking is free. We don't look at the impact on the neighborhood for free parking. We often have parking garages that are free. And we have parking garages that charge, but the utilization rates don't look at the.
Well, I think the parking
numbers.
study looked at the way the peak number of patrons and where they were parking. So, I mean, as long as we could have the capacity for that peak number of patrons, I don't think we're going to increase the number of people who use that bank.
Yeah, certainly not the people who come to use the bank.
No, but it is based on those numbers are based on the ride share of people choosing to walk or take the bus, and people will make those decisions based on whether or not there is parking available and whether it is free. And that there's studies that show that people will say, there's no good parking here, or I have to pay $3 to park here, and so I'll take the bus,
But
I'll walk.
according to the study, there's all this on-street parking, so people have already made that decision that this is a great place to come because there's lots of free parking in the area.
On street.
On street's not
street.
free. I mean, it is within a
All right,
walking
but-
distance, but, immediately adjacent to the shopping center, it's metered.
But there's something problematic for me to say that we have loads of vacant spaces on this lot. When the
understand that.
reality is, we do only because we're charging for them.
charging
That's a
more.
problem. And then using that to then get a reduction in the amount of required spots, that's, it's kind of gaming the system to me.
Yeah, I agree. And I also don't think, I've never seen us factor in on any of these studies the price that's being charged for the proposed spaces.
Which is also a reason why it is difficult now to start doing that on one case.
No, we have, for instance, we have a medical office where we know that
I'm
it's
just
free.
saying that's caution and that absolutely free.
It's not absolutely free, it's only to pay for.
Parking validate, but it's
trouble to get parking validations. You have to make a special effort.
Staff has made its recommendation.
Okay.
You have heard it, so.
Okay, all right. So I'm sticking with this position. I don't know if other commissioners feel the same way. I just think that right now, the parking charging is a discourages the use of the parking lot. And we also have the legalization, don't forget, of this construction. So it seems like the owner needs to step up.
I will say this, facility as noted previously, it runs on a deficit already, and it was very difficult to find an operator to come in and do this.
No, but it's
so-
not about the operator.
I understand.
This is the owner's job, right? The owner is benefiting from additional construction that needs to be legalized, as Commissioner Otley-Brown pointed out, is the source of additional income. The parking was supposed to be on the site on which the building now is situated, et cetera, yeah.
Right, it's an accessory parking garage. It's not it's supposed to be accessory to the uses on the site.
A point of clarification, the proposed parking layout that's been submitted, is that based on a self-parking layout that DOB would,
Yes.
and that is because
Dennis Knox can speak to that. That was looked at very closely.
Why, is there concern about the self-parking? No. No, obviously, if with self-parking, it brings down the costs of operating the
Sure.
garage.
Yeah.
Right, and
That could reduce the charge, but like sort of naturally, right? I mean.
Right, exactly.
Okay. All right. I think we've gone over everything, so.
Sure. Transportation planner Noah Bernstein from VHB would like to say something.
Okay.
Noah Bernstein, VHB. We worked on the parking study, and I just wanted to just point out a couple of things for the board's consideration. Uniqueness of the site. So, I mean, the site is, regardless of how you tweak the parking pricing, you have to recognize the fact that there is ample, convenient, much more convenient parking on the street right in front of the storefronts. There is free parking right across the street, and we've observed that there is some sharing of trips between the site between our site and the shopping site across the street. So even if you change the parking, there's still just a matter of convenience there. And this one could look at the special permit as an opportunity to balance the parking in the area. You as much as you want to provide, good planning is finding the perfect mean. You don't want to underbuild parking, you don't want to overbuild parking. And if not for the special permit, then you'd have to build even more spaces and find ways to park, fill up those spots. So if there's already plenty of availability in the parking and the existing conditions, why look into building more parking, which is what would be without the special permit?
Why would you look at building more parking?
In other words,
Sorry?
there would be no need for the as of right amount of parking, the amount required by zoning. So the special permit balances out the supply with the demand, more or less.
Okay, so to be clear, we would never consider a special permit where demand is exceeding the amount of spaces that are being provided. Otherwise, everyone just goes home, right? So the study established that the demand doesn't exceed the spaces provided. But the fact that the garage is empty means demand, which is established by the study, is being met someplace else. So that's kind of illogical, right? It's being met someplace else for a reason, because there's free parking across the street at the supermarket. And so, so we go back again. The reason we want to encourage the use of this is so that the demand of the supermarket and all of the other businesses that are taking advantage of the supermarket is met for the supermarket, because arguably, people want to go to the supermarket, can't park at the supermarket,
Well,
right?
suppose the supermarket or that shopping center wants to expand, and they want to come to us for a parking reduction. I mean, they do a study, and they can't reduce their parking because the people for your facility are parking across the street. It's just fair.
I wouldn't say that the demand from our facility is being accommodated
Well, that's in your
primarily
study.
by the
Well, maybe not primarily, but partially.
by the supermarket.
Well,
Is
that was
by-
included as part of what's available parking, 78 spaces.
And it's also
The
indicated.
78 spaces is not just for the. There's 78 spaces for that entire shopping strip,
Yeah.
and then there's additional parking for the supermarket, the Aldi supermarket
No,
across
that's
the street.
parking.
And then there's street parking above and beyond that.
No, it says shopping center across Nostrand has 78 spaces,
I
assuming
believe-
linked trips.
But there's also 45 on-street metered spaces,
Right.
just on the block on Nostrand. Additional metered spaces down the block on either end. around the
And
corner.
you just observed that there were sort of shared parking.
Yeah, this wasn't-
occurring, it's not like it's.
Right.
Yeah.
This wasn't.
We don't really know.
Well, we don't really know, but it was observed.
We don't have hard counts of every single
Sure.
possible trip between.
Right, yeah, but
Okay.
it's usually safe to assume that it's going to happen.
Proposed 77, okay. Okay, so, all right, I think we've,
I talked that one today.
I have two other things to say. The parking study looked at the site specifically, how many parking spaces were there, what was happening at the site. A next step would be to look at the area, to see what's being drawn, if there really is some excess, demand that's being placed on the shopping center with the free parking across the street. Part of their observations at the site, they saw people sharing trips, walking back and forth.
Right.
You park your car once, you don't want to move it again. It's a very common
That would
phenomenon.
occur.
So I would offer that up, because I'm concerned about the board establishing some sort of pricing that, will be permanent into the future, forever at this facility, without really knowing what's going to happen.
Well, so here's the thing. Your study showed what your demand is for the facility, right? And everybody else who's coming for other reasons has to pay, right? And the people who come initially, they'll get a little ticket, right? And then they'll go into the store and validate the ticket, and the validation, say, is only good for an hour, so you get to park for an hour, right? I don't see how that throws off the entire viability of a parking garage that's open to the patrons of another thing across the street, right? Or how in the world that's gonna cause a rush on the parking garage, because all of a sudden it's free for an hour to the patrons of the bank.
I think a short increment, that seems to make more sense to me. I was concerned it would be a much greater period of time.
Okay, no, we talked about an hour or two, so, something reasonable.
Parking is,
Yeah.
an hour parking on the curb outside. For a dollar.
That
At
sound
least to
right?
make it, more competitive or cheaper than if you parked at the curb, so there's an incentive to actually use the garage.
I understand where the board is going, just understand, the owner's concerns.
Okay. All right, so I think we've done everything. So I think we went through all of the issues, and so we need you to make a submission on those issues for August 22nd?
I think that'll work.
Yeah.
Hold on, let me-
So August 22nd would mean a submission on August 2nd? Does that work?
We can do that, but to be clear, we're not submitting anything additional on the parking garage, it's really just the rear yard improvements?
Yes.
Okay, so there's not,
Well, it's also about the sign, the corner sign. You're going to need to go, if you're uncomfortable about getting a permit just like that on the sign on the corner for the parking, then if you want to go to get a ZRD1, that's your choice, because as far as I'm concerned, Mr. Colgate's very capable of persuading DOB that that sign is totally within the confines of the intention of the zoning resolution.
and is the board thinking that they will make, as a condition of their approval, a requirement for the signage on the bank, so that the owner would then have, the power of the law behind them in dealing with their tenant?
Definitely.
Okay.
Okay.
So, August 22nd.
Right. Great, thank you. Okay, how's everybody feeling? Anybody want a break?
One more?
It's 1 o'clock, one more? Z is a little tricky.
Yes.
This one's gonna take 20 minutes, something like that. Is everybody okay with that? Okay, so let's go on to the next one.
Item number 14, 105 15BZ, 2102, 2124 Avenue Z, Brooklyn. What are we doing?
Hold on.
Wait.
They're all collated. Sorry about the rubber
How many
band.
sets are there?
Sorry. There's one set for everybody.
Is that for everybody?
And there's nothing really new in there.
For you.
There's nothing so new within there, other than the rendering, of course, up front. But the plans have been relabeled. You were right yesterday when we looked at everything. It got complicated when we were putting this all together, and we mislabeled the plans. So we relabeled all the plans you had before. That's what all the plans are. Same plans, just labeled so you can clearly understand them. And Renzo's rendering.
Yeah, I'm like impressed that with the rendering, the architect should give lessons to a lot of the other.
He's here. He'll be happy to hear that.
Yeah.
He doesn't like it, though. He hates it. He's a modern guy. I go, Renzo, you like it? He's like, I'm a modern guy.
No, but the technique, the skills, I
No,
want
Renzo's a good architect.
tutorial or something to.
He's a good architect, albeit more of a modernistic guy. He's, but, so Renzo is here too to answer a lot of your questions.
Are you for Avenue Z? Do you have another copy, so they can see?
Oh, yeah, there might be an extra copy. Thank you. Thank you.
Thank you.
So we attended your review session yesterday. We heard your comments about the wet versus dry flood proof, and you were in fact correct. Renzo went back and confirmed everything, and he'll speak to that in a second, but in fact, it does need to be dry flood proofed. So we will be amending the proposal. Any proposal, should your board approve it, will be dry flood proofed. And we're not claiming the dry flood proofing as a condition in our numbers at all. So that will be corrected, and we'll submit that after the hearing. The other issue that came up yesterday, let me just get my notes here, which Renzo's going to speak to in a minute, is the loss factor. We've put together for you in the plan package that you have, it's plan package C, Plan C, which is really the proposal. That's Plan C. That's the two-story building with, or really three stories. We keep calling it two because it's got a cellar in it, but it's really, I say to my mother would look at it and say it's a three-story building with no parking on the ground floor, because my mother knows nothing about zoning, so she would view it as a three-story building. You had asked on that, if you go to Plan Sheet 15A, and I guess Renzo, you should probably just come up and speak to it right off the bat, because I saw Commissioner Montanez raising her head up when I mentioned it. Plan Sheet 15A of that plan sheet has been revised overnight. That's the only new plan sheet that's been created overnight. And what they've done there is shade out the areas that were deducted as non-rentable floor area in order to show you how they got to their floor area. Because there were some questions about the deduction.
This one, on the
Are you still using
version C.
the design flood elevation of 12?
You should just introduce yourself.
Renzo Bellardi.
It has to be 11.
Wait, let him,
Oh, okay, sorry.
say it again, I'm sorry.
Renzo Bellardi.
Renzo Bellardi, okay.
The story with the DFE, according to the code, the chart says it's the minimum elevation, so the minimum is
Oh,
1.
you can lift things above, but
Correct.
the DFE is defined. It's for commercial space, it's the base flood elevation plus 1 according to the ASCE occupancy.
Is the minimum DFE.
No, we already went to the DOB and talked to them about
Okay.
this. They don't agree with you.
Okay, okay.
So it's not there's no such thing as a minimum DFE, there's a DFE.
There's a DFE, right.
But
You can't define the DFE. It's defined by FEMA and that chart.
Okay, correct. Okay.
Okay, but
So it's 12.
No, it's 11.
It's 11.
The drawings show 12.
Right.
So that just determines whether or not it's a cellar or not. That's the
Correct.
big impact.
what you said.
Well, that's it. Don't go anywhere if you need to. I guess that's,
Did she write this down? This is from Clinton.
Yes, I saw
yeah.
You saw that.
And then your staff forwarded that to us.
Yeah, oh, okay.
And Renzo has seen it also.
Yeah.
So the one issue that we're having esoterically as we speak to you about this issue is how the board perceives the cellar and what elevation it's at, whether you're viewing it, because we're counting the floor area obviously in all of our hardship calculations. So Renzo has been trying to lower the floor, if just to eliminate that floor area objection.
Right.
But now we have to go down another foot by this conversation, right? And I know, Madam Chair, we've spoken about this through a lot of time, and you have expressed to me
Right.
that you like it. We talked, at the last hearing, you suggested, we talked about syncing it together, but really, we've also spoken earlier that you like it at grade, and we would prefer to have it at grade.
Well,
So the question is, for the board, how you're viewing
Yeah,
this
yeah.
cellar versus
So the thing
non-cellar
is,
issue.
you have all of these opposing forces in this project, right? And one of them, of course, is the neighborhood character issue. And so the height, not everybody agrees, but I think your height is more in keeping with what neighborhood character says, because you're pretty much within that 35 feet
Yes,
drop-off that the
yeah.
neighborhood has, right? So lifting the building would undo the neighborhood character finding, right? So the fact that you have retail where you're going down, I think is unfortunate, but at the same time,
Sort of
it
stuck
cuts
with it. I
against
mean, we are where we
neighborhood
are,
character unless you reduce floor-to-floor height someplace else or something,
which is very
right?
hard to do, to get the
Right.
floor area, so.
And then in terms of the floor, for me, I often say this, you don't perceive FAR, so I don't really care whether that thing counts as a cellar or as a basement, as long as the massing fits within the neighborhood character.
We have something in
right?
common, that's how I look at everything. So the question that, for us, is do you feel strongly enough, I mean, the difference is 2 feet
Right.
on the appearance and the neighborhood character, and there are taller I don't have the paperwork in front of me, but we've given you,
Yeah,
to show you that
those aren't
everything
immediately-
across the street, on the other side of Avenue Z, are,
So
taller
what's the,
buildings.
yeah, what is the height of the buildings that are across this street on Avenue Z?
I can get them when we, as everybody's talking, I'm going to go back into my application and pull it out. It was in our original filing.
You
But
mean those
they're taller
apartment
buildings.
Yeah.
These guys?
Yeah, they're tall.
Yeah, but those are on an avenue, those are in a different
What's
zone.
directly across is what, 2 stories plus
Jerome
a
Avenue.
store
That's
in
not-
front?
Oh, that's not Avenue
What's the
Z.
height of the buildings?
Well, Jerome is smaller.
Sorry.
Jerome Avenue side is smaller.
but
That's
Jerome's
residential. The Avenue Z side is bigger. That's the commercial strip with taller grandfathered buildings and a scattering, mostly anywhere from 6 stories on the avenue to...
the ones,
On the opposite
Yeah.
road. What is that?
Across Avenue Z, you mean?
The other, the
I
other
think I
one.
got confused between Z and
Here,
Jerome.
here, Jerome, right?
Yeah. I need to look at the area.
It's Jerome, right? The Jerome
Yeah.
side is this.
The Jerome side is low scale.
Is this side.
Right, it's
That's
just
Jerome, and that's Avenue Z. But you can't use the apartment buildings that are on
No, I was
whatever.
referring to these.
Yeah, yeah,
Well,
so
this
those
is
are,
also-
no, that's also on the frontage, I think, of this, the big thing, Ocean, wherever that's called. Let me just-
Across
Thanks,
Avenue Z,
Jessica.
there's
That's very helpful.
little 3 stories. 2
Technology.
stories
Yeah.
plus retail on the first.
Right.
Yeah, so
No, I-
across the street, you're 3 stories. Across Avenue Z, those are taxpayers, basically, directly across
Ocean
Avenue Z.
It's Ocean Avenue that the taller building.
Ocean has the taller buildings.
Yeah, you can't use the Ocean
Yeah,
Avenue.
Ocean Avenue.
Right,
is on
so,
a
no, but I
one
was
frontage.
just asking if you were accommodating the
Yeah.
idea of, instead of being 32, being
Right.
34, which is the negligible difference
Well,
between...
it isn't 34.
35,
That's
excuse me.
That's measured off of design
Flood
flood. I'm
elevation.
measuring off of base, off of grade, because that's what you perceive on the street, right? So
Right, but
everyone walks
also,
around-
you get the benefit under the zoning of the design flood elevation being raised.
No, I'm not saying that it
I get
doesn't
it. It's a
comply with
perception of the street,
zoning.
yeah.
I'm talking about whether it fits with the neighborhood character that you perceve from grade.
That's your, of
Because
course, your
Nobody knows
decision.
where design flood is when they walk
Right.
around, when you're.
My mother.
Yeah.
I wish my grandmother was around. We'll leave it to the board to decide. We'll set forth the idea that we would love it if we could be a grade, for obvious reasons, and the 2 feet, I think my mother would not notice the difference. But having said that, it's your board and it's your decision.
Okay, and it has to do with the design of the building, et cetera, et cetera.
Yeah,
Okay.
so and Renzo is right here, and he could talk to you about the other issues you had. I think, well, the loss factor, I don't know if you were comfortable with that answer that we gave you.
Well, you didn't dimension the areas that were shaded out, so I could just follow your math. So you did shade it out, but it'd be helpful so that this way I could just see the calculations. Like you're saying that you're deducting for the difference between the thickness of the wall. But what is that, a foot?
Yes.
All the way around
Yes.
times the entire perimeter?
Correct.
Okay, and then your lobby areas that are going upstairs?
Correct.
Yeah, it would be helpful if you would dimension
Yeah, no problem.
those.
We just did it.
And then the loss factor on the 2nd and 3rd floor, you don't have that at all.
Again,
And that's an even greater difference. I think that's like 1,800 square feet of
Because there's a
floor.
common hallway that goes across the whole front of the building.
Right, which is there because you insist on partitioning this floor, which is
Correct.
what I raised an objection to last hearing, because that's, for a small building like this, that's a lot of space that you're not collecting any rent for that you're
correct.
having, but if you
That's
just
correct.
had it as one large space,
On the flip side, it might be more difficult to rent one big, large space.
I don't think it's that large a building that you would be having that issue.
It would be 16, 2,000, 3,600, and another 2,500. So it's about 5,000 square feet of rentable area that you have to rent to one tenant. That's the issue.
Well, but you're dividing it, like, just for argument's sake, you're dividing it into thirds instead of halves, like.
Do it in
what- Yeah, like why, how did you pick thirds?
You have you just need an
Yeah, no
elevator
corridor.
lobby with a
Right.
door off of each side, and then you're good.
Right.
Because there's just too much, you can't take 1,800 square feet out of a 7,900 square foot
Thing is,
floor.
we're not deducting it from square footage, we're just saying that it's not part of the tenant's rentable space.
No, no,
Well,
but
that's big, that's major.
it's affecting the
The
financials.
financials, it's really driving the financials is all of that space that you're losing on all 3 floors.
And then it always confuses me because whenever I rented space, they'll charge me for that corridor. They'll charge me for absolutely everything, stuff that doesn't even exist, they charge.
When I bought my apartment, I realized that they had a cinder block wall, demising wall running down the middle, a supporting wall, and I did the square footage analysis and realized how much I paid per square foot for the cinder block wall, so I
Right.
understand what you're talking about.
But that's an apartment, that's different than commercial.
Yeah, Will, Renzo, I think, understands it. But
Okay.
the question that you're raising, what you're suggesting is split into 2s instead of 3s? Is that the
Right,
idea?
the whole goal behind this is to increase the amount of net rentable space by a significant amount of square feet.
Understood. So we'll show you, we'll come, because it's more realistic. The office space in Brooklyn, in the outer borough, in this part of Brooklyn, is more realistic to be a series of smaller office users. It's, you know, like an accountant, a lawyer, any small business, really. So it's not so unfathomable that he split them up into 3 2,000 square feet offices. I mean, my office is about 900 square feet. So 2,000 square feet would be a monstrous place for me. And he's got them split up into about 1,500. The largest one is at 25. and
Right,
it
but you
tapers
guys are
up.
partitioning, so you could take the deduction, and we see plans here that just say office,
So-
with no partitioning and just an elevator and a lobby, and we don't care how you end up cutting it up.
So why
later,
don't,
as
yeah,
long as
I
you
know that,
don't
so what.
increase.
I get it. So why don't we, because I don't want to get us tied into either a plan-specific approval, where we show you 2 floors and then they rent it to 3. So why don't we let Renzo come up with what we feel would be an average calculation of a loss factor based upon what we just spoke about, and we show you that calculation, and we give it to you in a sample plan, but not in a plan that would be approved, so that way we're not locked, because we don't know if we're doing it 2 offices or 3 offices on the floor yet. We haven't
Well, you
figured-
would also impact the first floor, you don't need one versus 2 entrances.
If we
You
have,
need secondary egress.
well, we would need it,
Well,
if we have 2 per floor, we would need it no matter what.
You're right, okay.
So we would need that no matter what. But we understand where you're going, and I understand the board's point that you feel the deduction is too large. So we will tweak the deduction so that it comes down.
On all of your
on-
scenarios.
On all of the
so that we can
scenarios,
get a read
so
of
that you can
that.
get a better read, and we'll give it to Jack, too. Yeah, Jack, you want to speak? Come on up, Jack, you don't need to ask me, come on up, you're welcome.
Good afternoon, Jack Freeman. I'm here on behalf of the applicant. I think what I'd like to suggest in this matter is that we work with the architect. We generally rent out almost all of the square footage, and it really doesn't matter whether they divide it into 2, 1, or 3. So what I'd like to do is work with the architect and just identify what will be the things that would always be there, whether it's subdivided into 1 or more spaces, and we'll use that as the rentable area. My sense is that that's essentially going to be the elevator and the stairways, and everything else is going to be rentable.
Right, so it should bring your number up significantly.
I agree 100%.
Yeah.
We listened to what you said. So I'd like to just work with the architect, and for the financial analysis, we will just essentially deal with the rentable area, whether it's subdivided or not. And I think that will increase the rentable square footage. And that's
And
what we
everything
would-
else will stay the same. I don't expect the rent to go down.
I will not make
Okay.
one adjustment in the rents or the operating expenses. I've already looked at it that way, so it does bring the income up. It's still within what would be the margin of the minimum return. And for the other 2 options that were looked at, the lesser and the as-of-right, they are losing a significant amount of money, so it would be an insignificant effect. But
Okay.
we'll do that for the
So
record.
then that'll put the issue to bed.
Yes.
Absolutely. Thank you.
Thanks for speaking, Jack. Jessica, you should come get me quicker when Jack wants to speak.
Okay, I'm sorry.
So that's okay, you just missed a very exciting conversation about the financials.
I didn't totally miss it, I heard half. Okay.
So,
Okay.
some other, we were talking about the financials, we talked about the loss factor already, the design flood elevation. We talked about the fact that it's going to be a dry flood proof, not a wet flood proof.
Right.
And we're not going to include that cost. I think that, Madam Chair, if I could just raise the issues that I don't even want to raise, which is you had raised parking.
Yeah.
So that's my least favorite topic to discuss, but you wanted to discuss it.
Okay.
So we've given you, obviously, we have a site that's a hard site. So we have very tough spatial constraints. We can, as we've shown you in the alternative plans, cut up some of the first floor and put spaces in that. I think we fit 11 spaces in half of the first floor, right? When we did the wider part of the first floor. And we could certainly do that, if that's what the board would like to see. But that's what we're asking for, and what Jack has explained to me when I was speaking to Jack about it, is like, yeah, but then you lose the income, of course, and that hurts the
Understood.
financials.
Right.
So in Hiram, as much as sometimes, or Mr. Rothkrug, sometimes, his reports, you might find fault in it. In this one, he actually did a pretty good report, and it showed that there's actually a ton of spaces to accommodate our parking demand.
I wouldn't say
Not a ton, but
exactly a ton.
we meet
No.
the demand on the street.
Right, but so that's the thing, so and
So
again.
that's
with
the whole
Yeah, but-
pot of stuff, so then the question is, where do you think the stew should go?
Right, so, and it's to see, because one of the lesser variances that you did that had parking on the ground floor, had a lot of parking on the ground floor, so you were, and a very little bit of retail. So my question is, what if you flip that ratio?
Which scenario is that you're talking about the one that had 2 floors of parking and 27 spaces?
No,
or-
the one that just
Or the one that
had-
had 11A, the one that had 11 spaces?
Yeah.
But with that one, I mean, again, that's for Mr. Freeman to calculate and do the math based on corrections in loss factor and all that sort of stuff. But what I was thinking is, you take like the the way the retail is subdivided right now on your proposed, I guess that's plan.
That's scenario, which one is it?
Plan
Lose
A.
track.
Plan A? Okay.
No, excuse me, no,
No,
Plan
Plan C.
Plan C was proposed.
Which you call compliant two-story building with 0 parking spaces.
Yeah.
I don't understand these labels. You
No,
can't be
We're
compliant.
working through, we apologize. We were certainly working through some labeling issues that
Okay.
came to the attention last night, and we apologize for
Okay,
that.
so non-compliant,
Sometimes we overthink
two-story
things.
with 0
Plan C,
parking.
yes.
Okay, so Plan C has the fatter side of the triangle.
Right.
That's what is that? The base of the triangle. Has a commercial space A, which has 2,400 square feet of space in it. What if that space was looked at for stuffing in as much parking as you could, even arguably
You
with
have that.
stackers?
Yeah, you have that, Plan Sheet A.
Plan sheet A?
Or which one?
What?
Yeah, the Plan A.
Of P3.
That's what you have.
Plan A,
Shows you that floor, just like you're talking.
But it's more than.
no, but this has the partial third floor. This is.
Right, but no, I'm not talking to the building,
No,
I'm
no,
talking to what you're
no, we
suggesting.
don't have that, so that's the point, is Plan P3? you mean?
Yeah, is that
So,
what you were
no,
envisioning?
no, I'm looking at only the back third. So if you look at,
The 46.
if you look at page 15, drawing page
Right, I'm
15
going to 15.
of set C, Plan C,
You just put parking on that
For
one.
that
retail-
Yes, in that one
46
retail
foot wide
space.
space.
and you squash it in there. So it's valet parking. You see?
You're saying, hold on, slow down.
So let's
So,
just-
you're suggesting, there's the 3 commercial spaces, space A, B, and C.
Right, so
You're
space
suggesting-
A,
Space A,
and you get rid of the staircase there, obviously, because it's in the way. And you devote that space to parking, where you put even stackers in, which we've learned need clearance of, I forget, 9 feet something for stackers. You put stackers in there and you see how many spaces you can get in, where maybe you have even an in and out driveway. I'm not sure that that's allowed, but anyway, an in and out drive. So you pull in, you go into your stacker and you drive out.
here's a couple, Renzo's
And
whispering
you
in
and
my
I
ear.
know a lot about stackers recently. right?
We do, but that conversation, when we got out of there, that conversation we have to talk about. There's an economy of scale on these things, so there's electric.
Right, no, but I don't mean.
This isn't one of them. But here's Renzo's gonna look at it. He's whispering in my ear that you can get 8 to 10 spaces maybe, and Jack, of course, will do the numbers.
Okay.
My retort back on that issue is, first of all, do you really want to bring all the parking back there? Because what's happening now is the very same people that are here that are now getting no activity from the commercial, and it's pretty much segregated from them, everything is going to front on Avenue Z, is now bringing people to the back, to the houses. That's number one, which we're fine with, but,
Say that again, you're gonna
Why?
bring cars to the.
well, the idea was to put a curb cut there, wasn't it?
No, it's on the Avenue Z.
No, one idea, I'm not gonna design the parking, but one idea was that you go through.
Well, you can't put a
so
curb
you
cut
go
within
from-
50 feet of the intersection. That's,
Oh, so it can't be on the,
we're limited by the
Yeah,
location of
right,
curb
no,
cuts.
Within 50 foot, yeah. Wait, now I'm lost about the site plan. Where's your site plan?
But we'll look at it all, the only reason I'm saying anything is because really Hiram's giving you the report saying there's on-street parking, you're getting what's it called, Flatiron kind of building with,
Yeah.
you're gonna get a bunch of small little people in there like
No,
me, and,
so here's the thing, we have the community concerned about
course.
parking. We have to
Oh.
be able to understand and have studied whether parking is a possibility on this skinny triangle, right?
And we're gonna analyze it.
The only place that it can be is on the fat part of the triangle.
Of course.
So there are curb cut rules about where you put the curb cut. So within the confines of the curb cut rules, look at that.
We'll look at it
See
and
whether-
analyze it.
Okay?
We're scared about it, but we'll look at it.
Fear is a good thing.
I faced it a couple of times this week. So we'll take a look at that and study it and tell you how it vets out.
Okay, good.
And I think that was
Yeah.
What about
the essence
the
of most of your comments.
condition of the site? The last time you.
This is a favorite subject today, I know, I'm coming into a minefield today. This is like the third hearing on this.
The last time you were here, you said that the
Yes.
new owner was going to take over.
We're having a lot of trouble. We can't even get on to do a phase 2 yet. We're having to do our borings.
Why?
He's denying us access to the site, the current operator. He's not letting us on. So
The new owner owns it now?
yes, people don't always listen to everything everybody else says. So this guy's being stubborn, the guy that's coming out of the property. He's not the owner, he's a tenant. He's being stubborn with the current owner. We're trying to get him out of there, and we're trying to get the rigging onto the site to do the phase 2. We haven't been able to accomplish either of them yet. We can't even get the rigging onto the site, and we have money at stake if we don't dig right now. So the client is more upset than you are that we can't get onto the site.
When does the lease run out on this?
I think the lease is up, he's a holdover at this point.
Then I don't understand. I mean, you can just lock the gate.
Can't just go and lock gate, they call the police come over, it becomes a dispute, and then the sheriff comes, and then the sheriff says you have to go to court and get a court order, and they're gonna protect the person that's in possession until you go to court. They're not gonna evict, the police will not evict anybody.
So you can't even get the vehicles off
We
the
can't get the vehicle, we
sidewalk?
can't get anything off the site. We're trying to get the guy, we're trying to get him out of there right now. We don't even want him there. We don't want him on the
Why don't
site.
you go to the DOB and ask for?
That's the next, no, DOB won't do it. We're gonna go to court.
Can't
The
they
owner's
tow,
going to court.
won't they tow it, like DOT or something?
No, it's stealing.
or-
Oh, DOT can, yes.
Yeah.
DOT has
Call
the right.
DOT
DOT, of
and
course.
tow 'em.
But we can't tow them. We'd be arrested for grand theft if we stole them. You would be. When my brother was in college, his car ran out of gas, and he went to go get it the next morning. They had towed it to the local shop. The police, he didn't know that, so he put gas in it. He took the car. He got arrested for grand theft of his own car. But the point is, it just made me think of that story. The point is that we want him out more than you. I mean, the property's been here in the variance for a long time. The owners closed on the property nearly a year ago already. So the condition of the site is to us too. We want him out.
So
And we know it's
you are
horrible.
going to enforce
Either
against him now?
either he's out within the next few weeks, or the owner's taking him to court in a private action, and we'll force an eviction.
Okay. And there's no way that you can force as the owner compliance by removing the cars?
No, we can't touch the
Without
site.
Without a court
Without a
order?
court order, it'd be,
Even though they're on the public sidewalk?
yeah, but that just makes it legal for the city or the state or the
That's
federal government to go and do it.
So that's a DOT
We're not allowed to touch
enforcement.
it.
And actually, we should make note of that, we should be calling DOT or, yeah.
And by the way, this is not uncommon with this operator, if you ask the people that are here today to speak about the condition of the site through the past 15 years, this has been a constant at the site. This is not anything that's new with this operator,
Okay,
unfortunately.
all right. Are there any speakers? There are speakers on this.
Please state your name for the record, and you'll have 3 minutes to speak.
Hi, my name's Larry D'Ambrosi. I live across from the proposed site here, and he's correct as far as it being a mess for all these years. But the community, the people who live in this neighborhood are against such a massive structure being built. We feel it's very much out of character with our homes, and we see that across the street on Avenue Z, the structures are basically 2-story, and there are some 3, but 2-story. And there is nothing this massive. All of those stores also have yards behind them, I guess because they were moved to the frontage of Avenue Z. So to do something like this, to take up the whole property, we think is improper, and it would just be out of character with what we have there and where we live and things like that. And as far as to put something this big, to create this much traffic here, it doesn't make sense. Where are these people going to park? There's absolutely nowhere to park. I mean, people are still parking at safety zones. I have just one photo on my phone right now where there are cars that are parked at the safety zones because there is absolutely no parking whatsoever.
What do you mean at the safety zone?
Well, across the street on East 22nd, East 23rd Street, there's painted lines with the safety zone, and there are vehicles that are parked there.
They're parked on the painted lines?
Well, on the painted lines in the area next to it, they're not supposed to be.
They're not, they're actually, I have a Google image and it
Right.
shows the painted lines, but nobody's parked in it, they're parked alongside
Well,
it. That's not
well, even
allowed?
that's illegal. That's a no standing zone. I brought this up the last meeting I was here as well. But, you know, as of today, there are still people, homeowners and residents that have nowhere to park. One of my neighbors just told me yesterday he had to have 6 cars towed out of his driveway. He came home after a 14-hour shift, couldn't get into his driveway to park his car because there's no parking in front of his home, and he had to have the police come and ticket and tow at least 6 vehicles in the past year. This is typical of what's going on in the neighborhood. To create something like this would inflict more hardship than we've been enduring already with a variance that was given and not upheld in the right manner by the owner of the property. So to do this, to build a massive structure that looks like a, I don't know, blockhouse here next to homes and things like that, I think is just overdoing it. I mean, the building itself looks nice and it's appealing in certain ways, yeah, fine, that's great. But to take up that whole piece of land with a building and a structure, just for economic reasons, doesn't make sense to me. I mean, you know, laws were put down and rules were put down for the people who live there. Okay, you know, you want to put some stores in, fine, you want to create some parking, you know, I mean, yeah, fine, but to build the whole property does not make sense at all. Even the Rite Aid with that big property on Ocean Avenue, they're not doing it. They're providing parking for their customers, and it's a busy lot. People come in, they shop, and it's probably one of the most successful Rite Aids that I've seen. So to do something like this here is totally out of character and shouldn't be allowed. It's too big. It's really too big. You know, I heard your case just before, because that's my neighborhood, and I'm familiar with that area. And as a kid growing up, that area, those stores were never that massive. There were parking lots next to those stores. So people were able to park. Then they developed it more, they created more stores, and again, you have the parking issue where the people are parking in the lot across the street, walking across the street, double parkers using the bank, and so forth. And this would create the same thing in a worse way. You're taking away the parking. People, my home, I have a car, I can't park on the street. My lot is 100 by 100. My neighbor has 2 cars, they have parking in their driveway, they cannot park in front of their house either. The people across the street from me have no cars, the parking's all taken up. The person next to my neighbor has 1 car, they park in their driveway, there's no parking in front of their home. And again, continuously, down the block, there is no parking. The buildings that are up there are consuming the parking as is, that 6-story residential unit that's on Avenue Z. They're taking, many of the parking spots. So now to create more, I mean, it doesn't make sense at all. I mean, there's no planning here, there's no sense, yes. Right, and then too, like my sister just pointed out, that you have many people in transit there, parking and going to the subway, since it's a nice area to park, and taking, I mean, we have a little bit of that going on. But basically, it's people who live there who need parking, and they don't have it, it's not there. And
So it's people
More.
who live there who need parking, but they don't have parking themselves?
Correct.
Okay.
yes, they don't have
Where
parking
they have
themselves.
more than 1 car and they only
Well,
have parking for 1 car?
Even if you have, no, I wouldn't say they have more than 1 car. I'd say typically it's 1 car, because above those stores on Avenue Z, they're all apartments up there. So you're having, 4 or 6 residents there, and if they have a car, or even half of them have a car on Avenue Z, where do they park their cars? There's nowhere to park. You're going to create more, it's putting undue hardship on us. And as of today, some people came over to me today, this morning, and signed a petition, against this. And many more who are at work, they expressed to me too, their concern. And I'm sure we can triple the size of that signings that we have already, or even more than that they're against something like this being put up.
Just 1 second. Did you vote to your, no, so did you attend the community board?
Yes, it was
Yeah.
unanimous against this.
All right,
Yes,
thank
and there
you.
was a bigger showing there because of the convenience of coming in and parking again to, attend a meeting and things like that. And also too it was in the evening, the meeting, so you had many people show up because many people are working, and it's very difficult to come down and speak their voice. Okay.
Thank you very much.
Thank you, everyone.
Are there any other speakers on this? Okay. So going back to the parking question, I forgot to mention this. There was a letter that you provided from a real estate agent,
Yes.
right? And
That I
that,
tried to find a business in the area that would have any spaces to lease.
but it didn't come with any analysis. It didn't
We
say
can
what
give you who he's
spaces.
approached.
It didn't say what kind of negotiations, what kind of lots were looked at, nothing.
We can give you some
I mean, for
information.
instance, let's just say Rite Aid has parking, just for argument's sake, right? What if a deal was made with Rite Aid to get some parking on that lot, like with stackers or something like that? If you can hear the community, and the community board unanimously opposed this application in large part because of the parking concern, right? So, and you hear from the community that in spite of what the study says, that's not the community's perception of the parking conditions, right? So, and maybe, the parking study that looks at available on-street parking also looks at a broader range, because obviously people park right where they want to be,
Yeah.
right?
No, it studied that area. The other thing, too, to remember is that the building has been cut in half from the time of the committee board.
Yes.
It came in as a 4-story building. It came in with twice as much floor area and twice as much height.
Yes.
And I understand the concerns that they're expressing with parking, and with all due respect, it's the whole city of New York, everywhere you go. You talk to one New Yorker, you go to the Upper East Side, can't get a parking spot, anywhere. So that's everywhere, and I'm not debating that he might have trouble finding a spot. But also, if you look at this property, it is unique, it does have the problem. You just asked to analyze a couple more spots. It's small, local businesses, offices are going to be occupying it. So, for real, you were a lawyer in private practice before. You know as well as I do how many people come and see a lawyer on a busy day. It's not that many. And it's the same with Compared to a
that type
yogurt
of
shop.
lawyer.
Right, but compared to a yogurt shop, or compared to things like of that ilk. So all I'm just suggesting is, I'm not suggesting that doesn't have a valid gripe, I'm sure he does look for parking all the time. I mean, I know, I live in New York, I lived in New York, and we've all circled the streets for spots. But in this case, Hiram Rothkrug has done a report which clearly shows an abundance of spaces that meet the demand. You've asked for additional spaces. You do have a site that's just constrained as heck. It's just constrained, and the board has asked us to cut the building in half. The board has asked us to make the height compliant. We've agreed.
Right.
And,
So, but-
you know, we're trying. We're trying. We're not snubbing our nose at the concern. We are trying to address it.
So, because the neighbors probably didn't read all the materials that are pretty arcane and
Who would?
complex, there was a parking study that was done that looks at what the demand for parking would be on that site based on statistics that are accepted by the Department of Transportation for standard, say, amount of trips to a location, and then how many of those trips are local, as in people walk to them or take public transportation, and how many of those trips are taken by car, right? And after completing that study, they determined that there's a demand of 14 parking spaces, right?
Correct.
So it was the 14 spaces, based on the demand study, that we were looking to locate someplace.
And we're going
right?
to try to
So
find it.
one way is to locate them on site, right? On stackers with valet parking, however you do it, so you get as much retail as you can on the ground floor. Another way, it's only 14 spaces, is to make a deal with somebody nearby to get the 14 spaces there. I'm staring at that Rite Aid parking lot, and I'm saying, if they just doubled the spaces by having stackers, you'd improve the parking situation in the neighborhood.
He did approach Rite Aid. Rite Aid's corporate.
Okay.
A corporation, so Rite Aid, for that kind of arrangement, you really need an individual owner that's not bound by any kind of
You need a
regulations.
creative negotiating lawyer who doesn't get visited a lot.
If we can do that, but, right? I hope I'm that guy. I don't think I'm that good, though. But we'll look at trying to find some ways, though. I mean, we're just all considering all the same points, and I'm not discounting what this gentleman is saying, but I don't know if he's recognized that we did cut the building down by 25 feet or so, that we cut off 15,000 square feet of floor area. So the gigantic thing that we presented at the community board meeting that was towering above the houses is now down at the same height as the houses. That's the allowable height in the area. Every building, all the houses could go to that height.
So sorry, we can't have a discussion like that.
Sorry,
This
but
points out
I understand what you're
yeah,
saying.
something that I actually would also like to request. The board can't force you, but one of the reasons you're having so much trouble with the community is, not you personally, but your client, is because there is no community outreach. You can't just relegate this to the community board. I always call it milk and cookie time. There should be a time where the owner of the property invites everybody to a place where they can discuss the project and come to some reasonable compromise, right? Because meanwhile, the property can't remain vacant, and it's a terrible use right now, so a use of retail would be a more agreeable use, right?
I've been speaking to them, we've seen each other for 4 years already, right?
Okay.
You know, so I think it was your mother that was here before, right? Your mom?
Yes, just a few minutes of speaking.
Yeah.
You know?
So a little more community outreach.
We're happy to
might
talk
solve
to everybody,
this,
but at the end
okay?
of the day, we still have the same problem. We've got a flat iron-shaped building, just like in Manhattan, that's got, the only thing we're really asking you for now is to help alleviate the items that are obvious physical impediments at this point, which is the setbacks and the parking.
I have a question. I think one of the questions that we have been hearing is the neighborhood character. Now, in response to it, you have reduced the building height. There's still an outstanding question, which is regards to the length of the building. And I think based on my site visits, I did notice different types of building typology, including attached buildings, long slabs of attached building to small individual homes. I think you should look into the existing neighborhood characters, trying to show the building patterns and the street wall continuity and how this is similar or not similar. And Just,
Yeah.
that would be that would help us also and everybody else understanding
well, we're
how
hap-
this is more in context.
We're happy to
now.
give that to you. I think you'll see when you look at Avenue Z, it is continuous street walls the whole way down.
Right, not the whole, well, they're broken, there's different sizes, but I think that's an important part of the argument. How does this building, the way
It's
it's been
designed. We could show you that.
slightly, should there be more recesses? Should there be more articulation to make it look like, I'm looking at this row,
Well, now you
little three-story.
start coming down, everything we're talking about now is all great conversations, but now at some point, the project just becomes infeasible. I mean, now we're putting the 11 spaces
The
in.
architect get out of feasibility, let the architect work on
Gotcha.
it. But there's one typology that is very classic on Avenue C, which is a row of 5 little 3-story structures. And, well, this is a much taller one, but this.
Are you saying to maybe break up the facade differently and treat the facade different, or
I
you're saying the
can't.
structure itself?
Which one, this? Oh, yeah. Okay, and there's also
Like on
sort of a
21st.
townhome.
Like there are townhouses on 21st Street, you see, so you see mishmash of townhomes, individual, semi-detached. So I think you need to put that
Right.
eclectic mix together and indicate what's common, what's not, and kind of help make the argument for a continuous street wall, with a frontage of 200 on one side,
Yeah,
200.
yeah.
So-
And how you break up the massing in a way that's typical of the neighborhood, right? Because maybe this isn't quite doing it. This is more like decals. So, right.
So in essence, you'd like us to perhaps maybe try to make it look into individual buildings, even though they're,
Well, then
even though
you
it's a
would-
big building?
Yeah, because, if you just look at some of the typologies in the immediate neighborhood, you have a lot of
Different
hues.
material.
No, I understand.
Right,
And
so-
I've done projects like that.
Right?
Yeah.
Okay,
where it's
so
just all
take a
one
look
building,
at
but
that.
just-
So it doesn't look so, this is a little
Continuous.
bit, this is continuous, but it's also sort of applique,
Yes.
So
I
we don't want an applique look. It's, the idea is to really make it look like it's a row of little buildings, because that's what's typical of the neighborhood,
I've
right?
done projects like that.
I mean, and,
Good thing you were here.
yeah, and so just to point out, because the speaker mentioned this row of buildings that have rear yards, actually, there's tenement buildings on Avenue C that don't have any rear yards. If they have, some of them have little courtyards, but most of them don't have anything. So they're built full to the depth, which is quite deep. That looks like 100 feet deep. So, but you don't perceive that when you're on Avenue Z. You perceive these little 3-story structures that have kind of residential scale windows on the top. That's the other thing. The fenestration should be something that's sort of more typical of the neighborhood. Maybe that's another way of
Sure.
getting people to think of this as a friendly approach. Since it's offices, it doesn't need to have the same type of fenestration on the top as it does for retail on the ground floor, right? Okay, right? Okay. Good.
There were also some issues with the parking study. I think the transportation map was incorrect, was not for this site.
Do you want to,
And then there was no map of the municipal lots that were discussed.
I have that for you.
Okay. And I
State
think they're
your name,
over,
Mr. Roth.
Hiram Rutherford, I'm
I
sorry.
think they're both over a quarter of a mile away. Is that generally considered?
It's, according to the secret manual, we could actually go a half-mile away, but we don't consider this for the medical patients. We would consider it more for employees and staff. We don't think that it would be right to, for people coming to a medical office to park over a quarter mile away.
Right, yeah, I didn't think that was,
But I did hear your comments, and we did create a map for you.
okay.
Okay. Thank you. So it's a little-
Hi, Eric Fleming. So to summarize,
Did you need, Mr. Rothberg, there's this, you need this?
That was my secret response.
Yeah, I saw.
secret response. That's funny. That's funny stuff. You had asked us to show dry flood proofing to change the design flood elevation to 11 to show calculations for the loss factor on all floors. You'd asked us, Jack is going to be increasing the rentable square footage in all scenarios. We're going to look at adding parking, the quote-unquote fat part of the property, to see if we could fit in approximately 11 spaces or however many we can get in, as many as we can get in. We're going to look at other lots for parking, although I'm not very excited about the prospect of that occurring, but we will look.
And it shouldn't be a letter from a broker saying, I looked, but I could not find.
No, it'll be a proactive effort, and he is this is a local guy. He's on the streets of Brooklyn all day long. I mean, he knows everybody.
So if he knows
So he's out there.
everybody-
He's southwest Brooklyn, running around.
Ready
so.
to make a deal. I'm noting that this distance to the municipal lots is, if you're a crow, that's how far away it is. Otherwise, you walk following street patterns, and it makes it longer,
Yes.
right?
I would say for this, use the Google map and put the man in there to show.
That's a
Yeah.
good
How long
idea.
it takes
How
to
long does
walk.
it take to walk?
Yeah, that's a little
And just
walk
use that.
thing.
And then the conversation you just had with Renzo about the street wall continuity, and the windows,
Massing,
and the fenestration.
massing. Right,
So,
okay.
we have all of your comments.
Yes. And of course, as you always do, you'll listen to the video and make sure you hit everything.
We watch those videos all the
I
time.
know, you're one of our biggest fans.
It's a big fan. My kids are they even know you all guys, everybody by name. Before Full House, they want to watch the board. Came back Full House. It's back again on Netflix. They watch it all the time. I can't believe it. August, hopefully, I would.
August 22?
August 20th is horrible for me. I'm praying for August 8th, and if you can't do that, August 15th.
8th, ooh.
Or August 15th.
15th.
August 22nd, I'm at Niagara Falls.
We can do.
15th?
We can do, yeah.
Okay, let's do 15th. Let's try not to put too many parking study ones
Yeah,
on
I've been
the
trying
same
to
day like
track
today.
this.
I'm just going to ask you to put the next one on, too, so.
Yeah.
But August 15th, and what do you want submission date? What day is good?
Submission August 2nd.
August
Oh, sorry,
15th?
no, wrong one.
July 26th.
July 26th.
August 15th, July 26th.
Right.
Okay.
Okay,
Thank you.
so for members of the public, they're going to come back for continued hearing on August 15th, and they have to submit materials on July 26th to us.
And on the way out, if you'd like, we'll swap info, and
Yeah.
I'll give you my stuff, and
So
we'll give you
can-
the materials so you know
Right,
what
so
you're
you
doing.
can contact him directly
Yeah.
for
No,
copies of
we've-
material?
It's been amicable to
Oh,
each
you
other
have,
through
so
the
you
years.
got it,
Yeah,
okay.
we're not at war with each other. I don't think he loves the application,
I
but
appreciate
we're talking.
them trying to fix the lot. That's very appreciative of that.
Yeah, no, your mom was very upset with it for years, I know, so thank you.
Thank you. Okay, we are going to take a break now. Sorry to the next applicants. We're going to take a 30-minute break. It's 10 after, so 20 after 2? 20 after 2.
Resume at 2:20?
Hey, Jess, you just grabbed